Wait, item number 7, my lord, criminal appeals. Can this be after the vacation?
Okay.
Break is almost upon us.
Okay. Now we are available. No.
Immediately after the.
On the prayer of Mr. Deepagi, learned counsel for the appellate, list this matter after vacation.
Oh.
Puja vacation, huh?
Yeah,
Yeah,
please,
My lordship, I beg to mention item number 2, my lordship.
Item number
The
2.
concern of the other party, this matter is listed on 4th of November.
Why?
Similar.
What
matter-
happened to that Supreme Court? The similar matter is pending before Supreme Court. What happened?
We don't have any.
2010 matter.
This matter may be listed on
And-
4th, my
and
lordship. They'll be
It's
coming.
challenge to the anti-tax. Is there still anti-tax still survives?
I have no idea.
Hmm? Who is appearing?
Mr. S. Ram.
Okay.
You find out. We'll take it up tomorrow. What is the? This has been. This is pending since 2010, and similar matter is pending before the Supreme Court. You take the obtain instruction. This matter, Mr. On the prayer of MSK Wang, learned counsel for the Learned State Council, that this matter be listed on 04/10/2020. You take instruction. You ask Mr. Tapin.
I feel Lordship.
Yes.
I beg to mention item number 6, Lordship. This
Item
matter
number?
was 6, Lordship.
6.
Matter was transferred from the Honorable Appeals Court, Lordship, and
Yes.
Senior Advocate Colin Gonsalves has appeared before the Apex Court, Lordship, and he will also appear before your Lordship. So can it be
Yes.
taken up after
What is the
vacation, Lordship?
response? Why are you not filing affidavit?
Lordship, we will file your lordship.
When?
Need some time, your lordship.
What do you want? Mister, what do you want?
Can it be come up after vacation, Lordship?
Why?
Senior Advocate Colin Gonsalves will appear in this matter, Lordship.
We'll wait for him.
Lordship.
We should wait for him.
Lordship, he will appear on the next date, Lordship.
3 weeks. 6.
On the prayer of Mr.
I Sakma, Lordship.
Learned Counsel for the petitioner. Learned Counsel of petitioner list this matter after 4 weeks. List of, in the meantime, the state may, in the meantime, respondents may file their response. You take it back.
Give me a message.
Lordship.
Take it,
Honorable Supreme Court, we have already filed affidavit, madam. That affidavit will suffice.
okay. Then in that case, state,
Lordship.
you just don't respond. This, in the meantime, state respondents may file their response. It's a very serious,
Yes.
you have to take it
Remand is
seriously.
All right.
Deeply obliged, Lordship.
May Lordship,
Yes,
Lordship, I beg to mention item number 4, Lordship.
yes.
On behalf of conducting counsel, Sri D.K. Das, Lordship.
Hmm.
Lordship, he had to leave in emergency due to some medical issue of his grandmother, Lordship. He telephonically instructed me to mention on his behalf, Lordship.
It was fixed on his consent.
Today
Yes,
was
Lordship.
fixed only for the instruction
Yes.
to be given by DSG, whether they are going to realignment or not, which one is approved. That's only, my lord.
My lord, I received instruction. My lord, as per the instruction, my lord, second approved alignment is the, my lord, the final approved alignment where the construction will take place.
That's all.
Construction is started.
Not yet. It's because, my lord, there was a past complaint on, by the public complaint for construction of the past approved alignment. And the subsequently second approved alignment as per the, my lord, the demand of the public. And as per the convenience of the other party also, my lord. Second one,
second alignment.
a second alignment,
Anything?
which is not going to affect the matter. My lord, in fact, I have received a copy of the, my lord, the approved alignment, my lord, map, is case map,
Let us see.
stress of.
The
Since he is
problem is, council is on medical issue. What is to be done?
My lord, since it is a health issue, my lord, then my lord, we have accommodation, my lord, they deserve it, my lord.
Absolutely, my lord, I think the copy of, my lord, second one. It is stress from kilometer 1.1 to 15, my lord. And bordering to China. Second one. Original point, here point 150, that was the original. Revised is last version. It is in red color.
Yeah, my lordship.
And Mr. M. Kato, DAGY, Deputy Solicitor General PD. Next para. As directed by this court, Mr. M. Kato, learned counsel, has placed a copy of the revised alignment sketch map and submitted that and has submitted that the authorities have already finalized the alignment for construction of the road in question. Please note. The final approved alignment, the authorities have approved the second alignment and not the original one. Mr. Mr. However, Mr. Soin, learned counsel appearing for Mr. D.K. Das, learned counsel for the petitioner, submits that Mr. D.K. Das has some medical emergency for which he prays for listing the matter after 4 weeks. Mr. Next para. Although we find that the issue raised in this PL, privacy, does not have any cause. No, the PL, although we are privacy of the view that this PL doesn't have any cause to be adjudicated by this court under its public interest litigation jurisdiction, since the learned counsel is on is having medical emergency come up as a last opportunity. No, not as a last. Let the matter be listed after 4 weeks. After 4 weeks. On that day, we make close it.
Lordship, I also beg to mention item number 5, Lordship. The same council, Lordship, please.
What to do?
Yes, my lord, since there is a medical emergency, so my lord, I don't have much to object, my lord. However, my lord, this case was fixed by this noble court. Therefore,
Mr.
yesterday,
So
my
and
lord.
so, learned counsel for the petitioner. Learned counsel appearing for Mr. D.K. Das, learned counsel for the petitioner. Press for listing of the matter after 4 weeks. On the ground that Mr. D.K. Das has some has some medical emergency today. Mr. So and so, you record all them. Are present. Considering that the Mr. D.K. Das, learned counsel, he has some medical emergency come up. Let this matter be listed after 4 weeks. In the meantime, parties may file their respective affidavits.
I've already served a copy to Mr. D.K. Das.
If not, they already filed. What to do? We thought we'll dispose of both the cases.
My lord, appreciate my lord. Oblige, my lord.
Obliged, Lordship.
Lordship, since he agrees not to file any reply on this, let the matter be listed for disposal in some other day.
We'll admit and list
Ye-
it for here.
Yes,
My lord, that would be admit for hearing, my lord, but no stay will be there.
Why?
My lord, otherwise, my lord, admission hearing may be, my lord, taken today, my lord.
if
But
he
it
says
is for admission hearing only.
Yes, yes,
admission here,
that's why,
For
my lord.
admission only.
My lord, I will, my lord, object for interim only. There should be no entry.
Why?
Because, my lord,
Since matter needs to be heard, will stay.
but my lord, the problem is, my lord, they will issue a fresh
See,
advertisement.
What is the
Yes.
direction of this court? What is the judgment?
last.
Has to be carried out within a period of 1 month from the date of passing of this order.
Yes,
Unnecessary, you will file a contempt
Yes, my lord.
petition again.
My lord, otherwise, my lord, in my humble submission, my lord, in this appeal, my lord, there is no
You
any,
cannot-
my lord.
See, you cannot force them to fill it up. Even if you are selected, you don't have a right to be appointed.
That is true,
Law
my
is very clear.
that is true, my
So
lord.
you have clear only Baibabosi has to be done,
Yes,
I mean
ma'am.
conducted.
Yes, my lord. My
But
lord,
then there is certain allegations. It's infamous.
my lord, in that case, my lord, let, my lord,
We don't know whether this,
I may be
this
hard.
is a part of this area, the scheme or not. Allegations.
my lord, in that
When
case,
there is
my
a
lord,
doubt, when there is a cloud on the process, they have the authority, I mean, the power to cancel.
but my lord, from my perspective, my lord, the issue is, my lord, there is some complaint by my lord, organization.
Whatever may be,
Basing on that, my lord, complaint,
investigation is on.
no, my lord, there is no any investigation or
May
inquiry. my
not be particular to this recruitment process, but the entire within those period,
No, my lord,
these periods is under the cloud.
no, my lord, that is, this case is not covered on that
Is not it?
cases, my lord.
that
Okay,
is,
In view of that
that
allegations and the pendency of all these cases only, you have cancelled it.
that was the extent.
Yes.
No, my lord, that is not their stand taken in their affidavit of opposition filed in writ petition, my lord. My lord, otherwise, my lord, let me heard, my lord, on this admission.
Then you undertake that you will not file a contempt petition.
Yes, my lord, I will not file, my lord. Otherwise, I ought to have filed, my lord. It is more than 2 months, my lord.
Let the matter be listed
We
after
cannot
two.
compel you to do that. But then
Yes, my lord. I ought to have, my lord.
we'll stay this for a time being.
But-
We'll hear it after
2 weeks, after 2 weeks.
2 weeks.
But,
Whatever.
my lord, there will be, my lord, no press advertising, my lord. There will be no press advertising, my lord. That rather
We'll
may
not
be
say
given.
anything. We'll
But
not say
otherwise,
anything.
my
We'll
lord,
just
let
state
me
a judgment only.
2 weeks, after 2 weeks.
2 weeks after.
My lord, as I understood, my lord, after 2 weeks, but there will be no press advertisement. That rider should be there, my lord. There will be no press advertisement in respect of this 21 post, my lord. That rider should be there.
Not 21 posts, only 2 posts. We have 22 posts. So rest 20 posts cannot be barred for advertisement.
Otherwise, my lord,
At the most, two posts can be
this 2 posts, my lord.
subject to outcome. That
Anyway, we'll list it, admit in list after immediately after vacation.
yes.
We'll, hear the
But-
matter.
That rider should be there, my lord. So no press advertisement. Otherwise, my lord,
So will not
I
pass
will
anything.
advertisement.
Will not pass anything in that case. Heard Mr. A. Learned Counsel for the Learned Standing Counsel, APPSC for appellant. And also heard Mr. H. Lampu, Learned Counsel for the respondents.
Yes,
Two respondents.
yes, ma'am.
Yes,
Yes, yes. That's fine, none. We stated.
This is an intercourt. This intercourt appeal is directed against the judgment and order dated 11/06/2024, passed by the learned single judge in WPC 376 of 2022. Whereby the order dated 13/09/2022, passed by the Secretary APPSC, has been set aside. That order has been set aside.
Yes.
Has been set aside with a direction to conduct the interview oblique bibliography test for the post of for the bibliography to the respondents hearing in terms of the written examination result notification dated 09/09/2022. Admit the appeal and list for hearing after 2 weeks.
Oblige.
Just a moment, at least. Now appears for the petitioner on hold. Mr. D. Kandu, learned standing counsel.
Yes, my lord.
Land Management Department is present. Come on. In view of the withdrawal of the interlocutory application for filing an application for interlocutory application seeking leave to file an appeal against the judgment and order dated 23/06/2022. Come on. The writ appeal stands closed. That's all. Okay. Yes.
I would like to mention one unlisted matter at 2, my lord.
What is the urgency?
My lord, the ADC, my lord, had constituted the KEBA. The ADC has constituted a KEBA and directed to proceed with the KEBA
Writ
procedure.
petition.
Yes, my lord.
Why writ petition?
My lord, the ADC has passed the order. The ADC does not have any jurisdiction. He cannot take cognizance of the matter, of any complaint.
You filed 227.
226 also, my lord, is mentioned.
227 will be better.
ADC is not an authority, first of all.
Huh?
He is not an authority, competent authority.
That's why 227.
226, my lord. Because for 227, my lord, he has to be. my
Okay,
lord,
then we'll
authority.
see tomorrow.
My lord,
I'll go
urgency,
through.
because today, my lord,
I'll
it
go
has been
through.
fixed for Kebang, my lord.
Huh?
Kebang proceeding is going to help today, my lord.
Then what can we do?
Alright.
You might have started already.
Probably, my lord.
It's in the evening or what?
I cannot say, my lord, but
Then-
at least at 2, my lord. I've already filed. I've already filed. my lord. Obliged.
But you have to satisfy the maintainability.
Yes,
226. I doubt.
my lord.
All right.
All right.
Find out some judgment.
226, yes, obviously.
Hmm.
All right.
Mayor,
Yes.
Your Lordship, I pray for an adjournment of item number 32, Your Lordship. On the ground,
32.
yes, Your Lord, on the ground that my senior is out of station on personal difficulty. I have taken concern
On the prayer of Mr.
Ivan.
Ibam, London Council, for the petitioner, list this matter after 6 weeks. 4 weeks.
4 weeks.
4 weeks.
Highly available.
May I please, my lord?
Yes.
My lord, I beg to mention item number 33 and 34
33 and 34.
on behalf of Huay Dolo, my lord.
33 and 34.
33, 34 is
Yes.
taken consent from the opposite party.
Okay,
33, 34. I am for the petitioner. And on the last
there's
occasion,
no reply. No response has been filed. Affidavit has been filed.
No, my lord, I have just instructed to seeking adjournment.
affidavit has been filed. I
You are
have,
claiming your grievance is against the central government,
yes,
state as well.
state as well.
Which
But,
affidavit is
The
state?
state,
They have filed the affidavit.
they have filed the affidavit.
What about the central
My
government?
lord, I am for the respondent number 1 and 2, my lord.
So you are the main respondent.
Yes, madam. They are basically we are under process. Performer respondent types. No, madam. The land is under the position of the Indian Army, madam. So
Yeah.
therefore, madam, at this stage, madam, may I pray this, madam, I may be allowed to file affidavit. madam.
Why Dolo? Dolo is for.
Why the law is, madam, for the defendant number, respondent number.
Defense state,
Okay.
4 and
because
5.
all this acquisition are dealt by the defense state.
Okay.
So
It's all right. Are you objecting to the prayer
No, madam.
of adjournment?
Malad,
And we'll ask them to file a response also, because ultimately it may be dealt by the defense state officer, but then it's a.
on the last
central
occasion,
government is
Malad,
the main respondent.
on the last occasion, your lordship specifically directed Mr. Doloy, because since this is the defense state,
Hmm.
to convince the court whether land acquisition process has been followed as per law or not. That was the only issue.
Yeah.
Well, our contention is that though emblems has been followed, but not the
Yes,
Land Acquisition Act
Mr.
provision.
Doloy was directed to file affidavit.
Otherwise, my lord, in that case, if at all Doloy is having some problem, we can accommodate, but may I pray that this may be taken up on 23rd of
But
this
he will-
month.
He has to file an affidavit.
Yes.
It will be difficult to again.
20 days, I'm considering for 20 days, I mean, let it be on 23rd.
Not Mr. T, but the learned counsel for the petitioner. Different, same order, huh? But different. Separate order. Same order, but separate. This court on 0509/2024 has directed Mr. Y. Doloy, learned senior panel counsel for There's been for respond number 5 and 6 to file an affidavit. Mr. Palba, today Mr. M. Doji, Leonard Counsel, appearing on behalf of Mr. Roy Dole, press for adjournment of the matter in view of on the ground that Mr. Dole has some personal difficulty today. Considering the above, let this matter be listed after 3 weeks.
23rd.
3 weeks. Mr. Dole, Leonard Counsel to file an affidavit as directed by this court on 05/09/2024 before the next date.
Look, 23rd.
Before the next date of listing.
I beg to mention, WPC 634/2023 may be listed for today. It's termination matter. The petitioner don't want to pursue the matter further, so for
withdrawal.
withdrawal, yes,
Head to
much.
If it may please, Your Lordship, I beg to mention item number 28, 29, and 30.
20?
28, 29, and 30, Your Lordship.
Yes.
My Lord, yesterday it was mentioned for withdrawal, Your Lordship.
Withdraw.
Yes, Your Lordship.
28, 29, 30.
30.
Yes. MS D. Tamuk, Leonard Counsel for the petitioner submits that she has an instruction to withdraw this writ petition. Mr. Please, therefore, the writ petition may be allowed to be withdrawn. Mr. Kumar. The prayer for withdrawal is accepted. List of accordingly, the writ petition stands closed on withdrawal. Disposed of on withdrawal. No, closed on withdrawal.
Much obliged.
Separate order. But same order, but separate. In separate.
Much obliged.
Yes.
My Lordship,
Yes.
Lordship, I beg to mention item number.
Yes, sir.
Lordship, sorry. Item number 19, Lordship.
Huh?
Item number 19, Lordship.
19.
Lordship.
Yes.
The interim order I have challenging is the government has already amended my challenging that order, Lordship.
19.
19, Lordship.
Ramu Valley.
Lordship.
You want to withdraw?
Lordship.
Mr. K. Lolan.
Lordship.
Kirmani Lolan, Leonard Counsel for the petitioner submits that. You have been, your grievance has been redressed.
Lordship.
Why you want to withdraw?
Lordship, I'm challenging order has been amended by the government and this matter has been in practice. Lordship.
Okay, submits that the matter has become influxed before same may be closed. The accordingly, this petition stands closed on as influxus.
Obliged.
Lordship, this is a contempt case pertaining to
Beside,
contempt case pertaining to order dated 23 January 2024 by this honorable court in WPC number 8.
heard Mr. Swenson and counsel for the petitioner. This is an application under section 12 of Contempt of Court Act 1970 and renewed Article 15 of the Constitution of India and Rule 9 of Contempt of Courts within bracket Guwahati High Court bracket close rules 1977 page 1 alleging violation of willful disobedience and violation of the order dated 23/01/2024 passed in WPC number WPC 8 of 2024. Next issue notice returnable by 4 weeks. Next, whether the learned counsel for the petitioner to take steps for service of notice upon respondents by registered post so and so within 2 days.
Obliged,
List
Your
after 4 weeks.
May I please?
Yes.
Although in this case, my lord, notice what no suit. My lord, the respondent number 2 and 3 has filed their affidavit, my lord.
Saying that you have received the order
My lord,
with a signature and everything by
Yes,
your relatives, by your family members.
what, my lord?
What?
I have to say on that issue, my lord.
What?
My lord, let me file my affidavit in reply, my lord.
What
Because
reply?
this, my lord, this.
Your
this
only
person-
contention is that the order for
Letter of
notice-
acceptance.
letter of acceptance, where it stipulates that you have to submit the bank guarantee within 7 days.
Yes, ma'am.
You have not received that letter.
Yes, ma'am, my concern.
Now they have filed an affidavit saying that you have received it
Oh,
was issued on 12th,
14.
12th, and
was
you have
issued on, yes.
received on 14th.
Yes, my lord. But my
Letter
lord,
is there.
but my lord, who has received this, my lord?
In
letter of
fact,
acceptance?
you have suppressed.
No, my lord. This is, my lord, this person
It's
is
a
Puchat
suppression.
Wansu, my
It's a
lord.
suppression of material facts.
No, my lord, not. My lord, let me come up with, my lord, affidavit and reply.
What more?
My lord,
What
because
dismissing-
this Puchat Wansu, my lord.
We're dismissing it.
My lord, this person, my lord, who has received the letter of acceptance, my lord.
Are you disowning? He's not your relatives.
Yes, my lord.
He's not family member. He's not your family member.
Yes, my lord.
Then
He is not my relative. my lord.
Lordship, here, if Lordship see
My
the,
lord, let me come up with affidavit, my lord.
who is seriously bluffing? The state or you?
My lord, therefore, let me come up with an affidavit, my lord. Because it, my lord, it will, my lord, more for permanent. In my
You will
humble
be saying that he's not my relative.
Yes, ma'am.
All right.
Yes, my lord.
Was he staying in? Is he your enemy?
My lord, the death in this junction, my lord.
He was.
Almost same.
Is at your residence
Yes, ma'am.
and
No, no.
received the
He is my fellow blazer.
order. Huh?
He is my fellow blazer.
Huh.
That I admit that. But he is not residing with me. He is not my relative. And this letter has not handed over to me, my lord.
Are you alleging some malfeasance
My lord, against that
against the
person.
state residents?
Against the state respond in this petition, my lord. No, my lord.
Then
But my lord, let me, my
how
lord.
do you- no, the authority is supposed to issue the order
Yes, my lord.
communicating you.
Yes, my lord.
He cannot run. They cannot run after you.
My lord, that's true. That's my lord. They,
Suppose
he
you are in Delhi.
Yes, my lord.
They have issued an order today.
Yes, my lord.
Obviously, it will be sent to your home only.
Yes,
Whoever received it, it's his responsibility and your responsibility.
my lord.
I mean, it's hard to believe that after even 30 days, you did not receive for 30 days, you did not receive
Yes, my lord.
the order.
Thereafter-
It's very hard to believe.
My lord, that's true, my lord. That's I understood, my lord. But my lord, there is
So why
other
not-
side. My lord, other
In,
side
in
also.
that case, why not issue notice? We'll allow you to file reply. That's all.
Lordship, if Lordship see the read petition, Lordship. Here, Lordship, the prayer made is Lordship. A writ in nature of mandama shall not be issued directing the official respondent not to cancel the NIT, Lordship. NIT has been already cancelled, Lordship.
No,
Substantially, this writ petition has become process, Lordship. Apart from the merit, Lordship.
One more thing, if you have a fresh NIT,
Lordship.
there will be unnecessary expenditure. Are you saying that except for saying that he did not submit the bank guarantee as required within 7 days, are you saying that he will not be able to, he is not competent to do the work?
Lordship, that is actually not issued.
Because these are-
Till the dish,
It's not the submission and all this thing. It's not under any rule or under any act. It is as per the SBD or something
SBD,
like that, condition of the tender.
SBT, Lordship.
Why not allow him? Why is to incur more expenditure by issuing a fresh tender and all? If he is not incompetent.
Otherwise, my lord, he may be allowed,
But your
but some
conduct,
penalty may be imposed.
otherwise,
Yes, ma'am.
your conduct is something not appreciable.
My lord, yeah, so I agree, my lord. He
appears
should be
that
more vigilant, my lord. He should be more vigilant, my lord. Petitioner ought to have more vigilant. My lord. But my lord, if my lord, if my learned friend agrees, my lord, let his letter of, my lord, the bank guarantee may be, my lord, accepted, provided some penalty, some
not say
penalty.
with required penalty.
That is, my lord, 1% of the bank guarantee. That
What
is
do you
the,
say?
what?
Because he unnecessary
No,
will have to
There's aspect, Lordship, that I can do that.
incur further expenditure.
That part, Lordship, I can understand, Lordship. But when the decision was taken, Lordship,
You take you take in obstruction on this
instruction, I'll take, Lordship.
heard Mr. H. Lampu, learned counsel for the petitioner, and also heard Mr. S. Tafit, learned senior government advocate for the respondents. By filing this application, the petitioner has prayed for a direction to accept the performance guarantee or bank guarantee?
Performance guarantee.
Performance guarantee. In terms of the letter of acceptance dated 12/06/2024, issued by the executive engineer, Longding PW Division. Pursuant to the NIT, what is the date of NIT?
And I see that,
NIT dated 27/02/2024 for construction of OCR complex for IB unit of Longding under SIB Dibrugarh. List of the petitioner claims that the letter of where it is,
my lord, page 22. It's page 22.
Hmm?
Page 22, my lord.
21, 22. Letter of acceptance dated 12/06/2024 has never been served to the petitioner. List of next paragraph. Perusal of the letter of acceptance dated 12/06/2024 indicates that the petitioner has to furnish the performance guarantee oblique security for an amount equivalent to rupees 5,50,000 within 7 days of the issue of the letter of acceptance. Listen. Admittedly, the petitioner has not submitted the performance guarantee as directed by the authorities, as required to be submitted within 7 days from the issue of the letter of acceptance. Next paragraph. By the state respondents, by filing the state respondent has filed an affidavit and stated that the petitioner was the letter of acceptance was issued to the petitioner. By serving the copy which was received on 14/06/2024 by the family member of the proprietor of the family member of the petitioner, namely Sri Puchat Wangshu, as he had taken full responsibility and the recipient had put by with full responsibility by putting his signature and name in the office record of PWD, office record of PWD Pion Book by his own hand. Next matter. Mr. H. Lampu, learned counsel for the petitioner. H. Lampu, learned counsel. Press for has refuted such stand of the state respondents on the ground that the person who is stated to have received the letter of acceptance on 14/06/2024 is not related to him, though he is a co-villager. Therefore, he prays for some time to file reply to the affidavit. Next para. While granting the prayer of the learned counsel petitioner for further for 2 weeks, considering that the fresh NIT for the work may incur unnecessary expenditures which will be burden on the state of taker. And considering that the petitioner appears to have been selected after appears to have been selected after the NIT, and whether there being any incompetency to complete the work. The learned Mr. Estafin, learned counsel for the learned senior government advocate is directed to obtain instruction from the respondent authorities to the effect that respondent authority as to whether the petitioner can be allowed to as per the letter of acceptance by allowing him to furnish the performance guarantee with what?
With penalty,
Penalty. With penalty.
or fine,
With penalty. List this letter after 3 weeks.
Let's say a particular date can be given.
Yes. On.
22nd.
22nd.
Obliged.
Only to avoid unnecessary.
No, yes, that part.
Expenditure.
Obliged.
Malord, it's becoming customary.
Mr. Catherine, learn counsel for the petition and Mr. It's Tita, learn student counsel for health department. It is stated at the bar that the matter has become in list of accordingly, matter stands closed as in process.
Yes.
Where is that judgment?
Malord,
Where is that judgment?
judgment, Malord will find at page number 202, Malord.
Oh,
202.
202.
2. Starts from 202, Malord. It starts
Yes.
from 202, Malord.
Thereafter, there's another order of this court.
I'm not aware of it, Malord, because this was passed, 18 read petitions were filed, Malord, and it was club along and it was a common order.
Yes. Do you have any idea? After this, there was a subsequent order relying on this judgment.
Lots of.
Find out. We'll take it up at 10. We'll dispose it off.
Malord.
Lots of addresses that let notice go first.
What notice? Similar order, similarly situated.
Malord.
Same that ban order.
Yes,
and,
yes.
refuse to renew. Same. Of course, they are coming. Coming late, approaching the court belatedly.
Malord.
After this judgment, I mean, I think 2 months back,
Not so.
1 or 2 months back, basing on this, not an order itself, since it is a covert case, therefore we have disposed, the same benefits should also be,
Malord.
the same relief which has been granted in this judgment should also be granted to the petitioner. You find it out.
Malord.
Lots.
It will dispose it off. Or are you not agreeing that it is covered case?
Covered lots of.
Covered, then we'll dispose of. Why unnecessary keep it pending? Find out that judgment.
Malord.
A2.
It's Pagyum Koyu that you wrote the judgment.
Yes. Find out.
Even
Find out
we have
that-
to understand.
find out, get that order. Similar order will pass.
The subsequent one. Ashok Kumar is the original one.
Yes,
There's-
also Kumar is the original.
Yes.
Thereafter, subsequently
Yes,
relying on
my
that.
lord is also granted.
Yes, yes. That order you find out.
Yes. It's there.
Hmm.
Well, there's a caveat, man.
Yes.
Caveat. man.
Heard, Mr. Kegara. Keeper Gara.
Yes.
I have not seen you for some time.
Only comes in election cases.
Okay. Election expert
Hmm.
for the caveat. Caveat this third.
Number 3.
Huh?
Number 3.
And I will take your lordship only to the impugn order and the provisions of the act. So lordship may
What
kindly
is
have,
the allegation?
there are lots of allegations, but the finding is I have done anti-party activity, only that.
Yes.
How can that be?
Have you gone through the last week's order of the division bench?
Then the facts are totally different, man.
Yes.
Facts are totally different.
So you are saying that
Because,
only there are two
yes,
grounds
yes.
where
Section
the
3,
Jila Parishad
yes,
can be disqualified.
but
One
if
is,
they could have come to a finding
yes,
by adducing evidence, because it's a quasi-judicial authority,
Yes.
by adducing evidence that, oh, he has actually attended such a meeting, so Ravi Nayak applies, then I could have understood.
yes. Let us see the impugn order.
Page 107.
We are denying, they are alleging. So there are different
Page-
portions of 107 starts.
107.
Your lordship may kindly come to 110. Last paragraph.
Yes.
Heard the learned counsel of both parties. I have perused the case records. Before that, I will just, there was only oral hearing was done. Nothing was, there was no proceedings.
The records of the only complaint.
Yes.
And
They submitted some documents, pen drives and all. My lord knows pen drive, how this electronic evidence, section 65B has to be complied with. Nothing was done. No witnesses, nothing. Heard the learned counsel of both parties. I have perused the case records. It is found that the respondent has never attended any public rally programs related to official candidate for 26 ST. So this is one of the grounds. Assembly constituency BJP party. It is seen that the party has issued whips or directed to the respondent to support and campaign in favor of BJP official candidate on 22nd March by the state vice president such and such. Subsequently, Chairman State Disciplinary Action Committee has issued so-called notice to respondent on such and such for asking a written reply. It is seen that the respondent has given his written reply, but the Chairman State Disciplinary Action Committee BJP Arunachal Pradesh has issued expulsion order on 2nd May 2024 against the respondent. But I pause here, my lord. This has been put to challenge before the civil court. Civil court ultimately vacated it because I did not take steps. The district judge, my lord, restored it, the injunction. They came before lordships. That's why I considered on the last occasion, but they withdrew it. So the order of the London district has come back into force. My expulsion is no longer in force. There's an injunction against it.
There is an injunction.
Yes, because they withdrew it, my lord. They did not. I considered on the earlier day, your lordship will recall, those CRPs.
Yes.
They ultimately
They have
withdrew.
approached
Yes.
this court
Yes.
challenging that injunction order.
Yes.
So they have withdrew it.
They withdrew it. I considered, but they,
It's still pending.
no, they withdrew the.
No, that.
So that is pending. So
Before the
appellate
district-
order of the district judge has come back into force.
Okay.
So there's an injunction against my.
So
expulsion.
the matter is pending before
Now it's pending before the civil judge junior division, the original suit
against the
against the expulsion.
Okay.
Having perused the documents submitted by the counsel for the complainant, I am inclined to agree that the respondent has committed anti-party activity during his last general such and such. Before me, evidence of photographs and pen drive recorded speech of such and such. Considering all the submissions of learned counsel, I am considered view that the respondent has committed anti-party activity. I hereby disqualify him. So this is the reason. How can this be managed?
Yes. Yes.
Absolutely.
Yes, sir. You are for, caveator is for, you are for complainant. We'll hear them first.
My lord, so far, my lord, response number 2 is concerned, my lord, subject to your lordship correction and others, my lord. Now, my lord, in Panchayat Raj Act 1997, in any disqualification petition taken up by the Deputy Commissioner is a quasi-judicial matter.
Yes.
These are the my lord, judicial order, not the administrative order, my lord.
Yes.
So my point is only that in passing a quasi-judicial officer is a necessary party, my lord, to this proceeding, my lord.
See, there may be a reason that if he's expelled.
I can understand if there is any malafide or something allegations.
You have disqualified on the ground that found that he has been involved in anti-party activity.
I am not on that, my right order, wrong order, my lord.
This is
I
a
am
wrong
not on
order.
that.
You cannot. You cannot disqualify like this. After all, they are.
No, I'm only raising the question, is he necessary party or not? That's all, my lord.
Yes, he is in a constitution.
Who?
Deputy Commissioner.
The Deputy Commissioner.
Yes.
But this is a quasi-judicial order passed.
That's why quasi-judicial, therefore he's necessary.
My lord. Because generally, that's why I've said
Yes.
in my beginning, my lord, subject to your lordship
If it is a
correction.
purely judicial.
But these things already we've seen, my lord, in Nabum Revia case also. But that's why I raised this question, my subject to your lordship.
Nabum Revia has been referred to larger bench.
Yes, yes.
For reconsideration.
Now, my brother was referring to Ravi Nayak.
Hmm.
That entire, my lord, that was discussed in Nabum Revia. That had been referred to larger bench, my lord. Now that is pending.
Prima facie, it appears to be illegal.
My lord.
You cannot disqualify like this.
But
At
what?
least semblance of evidence should have been allowed to be taken. And the ground of, considering all shows the respondent has committed anti-party activity. I hereby disqualify him under section.
My lord,
Section 2(3) is very clear.
I have gone through the
I
other
don't-
parts with Deputy Commissioner, my lord, yes.
Had he mentioned even that they expelled from the party, then one can understand. Anti-party activities, how can you be?
That's why I was referring to section 3. And that meeting is in regard to meeting of the Jila Parishad, not the party meeting.
My lord,
Apparently, my lord.
order may not be very specific. So for anti-party is concerned, my lord, that
And that expulsion is has been
by the BJP
injunct-
party, yes.
Injunction is in his favor.
My lord, that I am not aware of that injunction, all these things.
I have annexed.
My lord, whether that was, my lord, produced before the Deputy Commissioner or not. My lord.
No,
Before
no,
passing.
There.
it was-
That was the ground
No,
taken.
that was before passing this impugn order, my lord.
Ah.
Whether the petitioner,
No,
the document-
expulsion, they have challenged before the civil court.
correct, my lord, they have obtained
They did
injunction
injunction.
order.
Against that, they have approached this court and they withdrawn the
Yes, my lord.
petition.
Against this expulsion order, they have obtained the injunction from the lower court. My question is whether that injunction order was placed before the Deputy Commissioner, before passing this, that's all, my lord.
It's okay.
Otherwise, this order could not have been passed, my lord.
Yes.
Your Lordship, yes, regarding the injunction order. The injunction order was stayed by this court. Then after
Injunction was stayed.
stayed by this court
Yes,
in CRP number 30.
yes.
And thereafter, the proceeding of disqualification was carried out.
Huh.
And accordingly, that disqualified order has been passed.
On what ground?
On the ground that he has voluntarily, Your Lordship, voluntarily
Given up the membership.
give up the.
Where it is?
It is in your paragraph number. He admittedly in his written statement also he admitted. You're in paragraph number in page number. He admitted in his written statement. In his written statement before the Deputy Commissioner. In the affidavit, Your Lordship.
No, impugn order, where it is in that,
Order,
He has-
order, it is mentioned.
where it is?
Mentioned in para number, Lordship, in para number A of the council for the council for response submitted in his written reply as under in para D 1010.
Which one?
110 page number. Page number 110. Para number D.
D.
It is clear that respondent submitted that he never absent any meeting called by the BJP, whereas supported Tabe Doni. This is the opposite candidate. MLA contesting candidate 26 Dumpurjo was active member of BJP, having primary membership numbers of census, active membership numbers census. After being Rodabui declared official candidate of BJP, respondent became dormant. He was inactive, dormant in participating all the party activities. Dormant.
Let us assuming that he had acted anti-party activities. Is it a ground for
Voluntarily
disqualification?
give up his membership.
Anti-acting, anti-party activities is a giving up membership, voluntary giving of membership. Where is this finding?
Yeah, dormant, he became dormant.
Forget about that. You just show us any finding of the Deputy Commissioner, which shows that his action amounts to giving up, voluntary giving up the membership of the party. Show us
Found on many occasions.
where it is.
In order, photographs.
Where not on photographs? Where on the order, impugn order?
It is reflected in the submission of the petition.
Where it is?
Complainant, it is reflected in. It was in record, Your Lordship. I have brought the all the activities done by the
We are not interested in activities. We're interested in, we're concerned with the reasons and reasons recorded in the impute order. So as
Your Honor, sir, in page number 109.
109.
The council court submitted that the respondent has supported NPP official candidate Tabeduni and the produced material evidence in pen drive. Speaking, Your Lordship, in a rally organized by the other party. This is pen drive has been perused, red in color, and also produced some color photographs of the respondent participated in the campaign in support of NPP MLA candidates. Supporting NPP active participation in opposite party and a dormant in the official candidate.
So is it,
It means that
is it according to agent amount to giving voluntary giving of
voluntarily he
giving up members,
gave up his responsibilities.
not responsibility,
Membership, Your Honor.
membership.
Membership. He voluntarily gave up membership from the official candidate of BJP party and he participated in the other party. That has been already perused and it has been brought in records before the Deputy Commissioner. On perusal of that records only, he had
All this
assumed.
all this record was proved.
Yes, sir, this thing.
Was it proved in accordance with the law?
It has been perused, Your Lordship.
Only perused.
Perused and it was,
Whatever you have made,
videograph-
whatever you have made a complaint,
plate.
whatever you made a complaint with any, all the documents are accepted without there being any.
Your Lordship, he was found having NPP start. He was,
Was it proved?
yes. He was.
Was it proved? All these things were proved or not?
It has been, Your Lordship.
Should have been
satisfied.
allowed him to rebut that also. Anyway, I don't see any
Your
ground of.
Lordship,
Yes, sir.
So per honorable court's order is concerned, therefore, this court is constrained to vacate the interim order dated so and so, so and so.
Which
So here on
Where it is?
Lordship, just a minute. Page 37.
37,
Yes, page 37.
27.
37. Oh, I have been, yeah, it's 37.
District judge.
Yes. Pending appeal, the operation of impugned order dated 24/6/2004 is suspended till next date. And the previous at interim order dated 24/5/24 shall be enforced till next date at Basar Court on 9/8/2024.
Yes.
August. After that, there is no extension order. So there is no injunction order in that aspect. If there is any other record other than this, I'm sorry. I'm from the records put up to us.
Either there is no order to vacate this order or any other order do you have
No.
after this?
After this, because I'm relying on the petition.
Shall be enforced till next date so and so, so and so. What happened thereafter?
Thereafter, the petitioner will be the better
I
person. to-
pointed it out just to show that the CRP has been withdrawn and there is an injunction order. This is immaterial to the facts of this case.
Anyway,
That I can get instruction, that is another thing. But
Yes.
ultimately,
well, instead is
the reasoning is
Other
at
than that-
110.
This last Honorable Chief Justice order, Lika Sang and Sore.
that was a case where it has clearly shown that they have
Yes.
given up voluntarily because
That is it.
resignation,
Yes.
merging, I mean, accepting to join the other political party. So it's obviously,
I'll just read out a single paragraph.
yeah.
The words voluntarily given up his membership are not synonymous with resignation and have a written connotation. A person may voluntarily give up his membership of a political party even though he has not tendered his resignation from the membership of that party. Even in absence of a formal resignation from membership, an interference can be drawn from the conduct of a member that he has voluntarily given up his membership of a political party to which he belongs. Now, of course, we are not with affidavit, but from the sequence of the events concerned here, it seems that he was with the other side campaigning for it. Now, there has, in the reply to the political BJP party, he says that I was on medical. That is the only ground he has pointed out. So now it is for us to interpret whether his absence in the campaign, election campaign, being ZPM for the official candidate was right or wrong. Allegation is that he was not campaigning. As also environment is that he was campaigning for Tabedoni without before distribution of party tickets. Thereafter, he fell ill. So of course, that is subject to evidence.
Cannot be ruled.
That's why.
So, I mean, the
So,
proceedings
This is what
of evidence should have been allowed. And,
So,
and
now-
strangely, the ground of disqualification is anti-party activities.
Now, order definitely is in very short form he has written, but there was a written reply, and also that shows so many things. Maybe from that records they have passed this order. I'm using the word maybe. Now, if honorable court wants to ascertain, the records may be called for.
Obviously, we'll call for the records.
Call for the records.
Till then, Your Lordship, they may not be granted.
Till then, we are granting it.
Your Lordship, I will,
They are elected representatives.
Yes. Well, at the very outset, I pointed.
You,
this is what
you could have properly guided the
Yes.
deputy commissioner.
I told him something earlier. I will tell him again afterwards.
Had Mr. Deepang, counsel for the petitioner. And also had Mr. Arich Nabab, London Additional Advocate General. For respondent number?
Respondent number 2.
Respondent number 3. Who is for 1?
Not a senior counsel.
Okay. Then you first read her, also had Mr. A of London Senior Counsel, assisted by Mr. So for respondent number 1, and then London Additional Advocate for respondent number 2, and Mr. K. Gara, London Counsel for the caveat respondent number 3. Challenge made in this writ petition is to the order dated 1809/2024, passed by the Deputy Commissioner, Upper Subaltern District, Dapurizia, whereby the petitioner has been disqualified as what is the Jilla Parishad member of what?
11 Bari Rijo Jilla Parishad constituency.
11 Bari Rijo Jilla Parishad constituency. Under section 3 of the Arunachal Pradesh Local Authorities Prohibition of Protection, Defection, Bracket Clause Act 2003. List of the issue notice returnable by 4 weeks. List of since the respondents are duly represented by the learned counsel, no formal notice need be served. Sent, however, extra copies to huh? Okay. Heard on the infant prayer. Next prayer. Perusal of the impute order dated 18/09/2024. Clearly, goes to show that the petitioner, the deputy commissioner, in excessive, the deputy commissioner has disqualified the petitioner on the ground of anti-party activities, activity. Anti-party activity. Mr. The disqualification has been invoked. The disqualification order has been issued, invoking section 3 of the Arunachal Pradesh Local Authorities Prohibition of Defection Act 2003. Section 3 of Section 3 provides as follows. You just called that. What is that? What is the volume?
No, it's the manual, Panchayat manual. It is in page 164.
160.
Section 3 is in 165.
160.
64, my lord, it starts.
64.
Section 3 is in 165.
Okay. It provides that subject to the provisions of section 5, 4, 5, and 6, a member belonging to any political party shall be disqualified for being such member if he has voluntarily given up his membership of such political party, or if he votes or abstains from voting in or intentionally remains absent from any meeting of the you just quote that, page 65. At best, it could have been clause A on voluntary giving up.
Yes, yes. Yes, sir, that is exactly what I said. They could have
On the please, thereafter, reading of the above provision shows that a member may enter disqualification on 2 grounds. On the disqualification only on the grounds of defection if he has voluntarily given up his membership of such political party, or if he votes are absent from voting in or intentionally remains absent from any meeting of the Jilla Parishad. Contrary to any direction issued by the political party to which he belongs to or by any person or authority authorized by it in this behalf without obtaining prior permission of such party. And such voting abstention or absence has not been condoned by such political party within 15 days from the date of voting of such abstention. Clause B will not apply.
No. They could have applied clause A. That is why
Clause
at
A.
the very beginning I said, they could have applied Ravi Nayak against me, but they didn't do so.
Yes. It is seen that the petitioner was expelled from the political party, namely Bharatiya Janata Party. On the ground of anti-party activities, on the alleged ground of anti-party activities. List of the the expulsion has been challenged against the expulsion. A suit has been filed before the civil court.
Yes.
Dapuria. Civil court junior division.
It was initially filed before the senior division, it has been now transferred to the junior division. It's pending before the
Civil court
of competent jurisdiction.
Civil court of competent jurisdiction. And then what happened?
Initially, my lord, the injunction was granted by the learned civil judge senior division. That was vacated, my lord.
And the civil court has granted injunction. However, same has been vacated on the ground of failing on the ground of
not taking steps within
not
time.
taking the steps within time. The vacation order was put to challenge, was taken, was, and no, please, an appeal was filed against the appeal.
Yes, appeal was filed.
Vacation of the injunction order by the civil judge before the district judge.
Yes, district judge.
District judge on
4/7/2024.
4/7/2027. Page this 37.
34, my lord. Yes, 37 is the operative portion. Restored the ad interim order dated 24/5/2024.
The district judge restored the injunction order that 24/05/2024.
Yes.
And suspended the order of expulsion.
Yes.
Dated 24/06/2024. Mr.
That order was.
It is submitted that the order of district judge is still in currency.
Yes, pursuant to the withdrawal of the civil division petition.
It was your worship, sorry for interrupting. The civil judge senior division has passed is not does not have jurisdiction. In peculiar jurisdiction falls within the JNFC.
That's why I considered earlier they withdrew.
And Civil Judge Senior Division has instead of.
That this revision was filed against that,
Order of the district judge.
okay, sister.
Unfortunately, they choose to
Notice that
withdraw.
The CRPC,
It
CRP
is
was not
noticed-
against the district court of order of the district judge. It
Against,
was against the order passed by the Civil Judge Senior Division, forwarding the title suit to the Junior Division. That against the.
anyway, I will not record and it's okay. Mr. Should I record your submission or we'll keep it for final? Should I record your submission?
Lordship, if proceedings of lower courts are recorded, then my submission may be recorded because it's question of interim order. So since lower court has not extended the interim order,
Mr. A. Upon Leonard, Senior Counsel, submits that since the order of injunction passed by the district judge is till 09/08/2024. Therefore, practically, there is no injunction order as on today, as the same has not been extended after 09/08/2024. Mr. R.S. Nabab, then Additional Advocate General. Submits, do you agree that semblance of proceedings should have been allowed to be taken place? What is your submission?
My lord, my submission is that, my lord, Deputy Commissioner passed the order, the present impugn order, based on the record whichever available before him, my lord. Because in that order he has said, my lord, after perusal of the records, my lord. So
Submits
although,
that.
my lord, it is not categorically mentioned in the order itself, but he
Submits
has said that.
Deputy Commissioner has passed the impugn order, was the disqualification of dated 18/9/2024. After consideration and perusal of the records presented before him. Which establishes the anti-party activities of the petitioner. And same amounts to giving of same amounts to voluntary giving of the membership of the political party, for which he has been rightly disqualified. Mr. K. Gara, learned counsel for the respondents. Respondent number 3. Submits that records, public documents placed before the Deputy Commissioner clearly establishes the anti-party activities on the part of the petitioner. And accordingly, no, please not. On the part of the petition, please not. On the clear act of the act of anti-party activities by the petitioner. He or she,
This is he.
the petitioner was expelled from the BJP, expelled from the political party, expelled from the party. Therefore, the petitioner has has been rightly disqualified the deputy commissioner on the ground of voluntary, or not on the ground, on the petitioner being voluntary given of the political party in accordance as per the law. As per the Arunachal Pradesh local authorities prohibition of within bracket, the prohibition of defection within bracket clause Act 2023. Next one. Having considered the submission of learned counsel for the parties and on perusal of the records, including perusal of the available records, available materials on record, including the impugn order of disqualification dated 1809/2024, passed by the Deputy Commissioner, Upper Subansiri District, I'm of the prime principle that the ground of disqualification as recorded in the impugn order is anti-party activity on the part of the petitioner, which would not be a ground for disqualification under section 3 of the Arunachal Pradesh local authorities prohibition of Act 2003. It was on the in the beginning you said when you mentioned they referred to as the Act of 2003, 2003. Mr. As noted above, the member, a member earned a disqualification on only on two grounds. Namely, so and so, you write those two grounds. This one. Does ever review that the disqualification of the petitioner appears to be not on the ground as under the provisions of the Act. Does I deem it appropriate? Does in my considered view says that disqualification has not been disqualification of petitioner has not been made under the as per the provisions of the Act, as per the relevant provisions of the Act of 2003, an interim order is called for. Accordingly, till the returnable date, the impugn order dated 1809/2024, passed by the Deputy Commissioner, Upper Subansiri District, Dapur region, still remains suspended. One more thing, if the complaint is filed, if the application is moved for if the complaint is filed for disqualification, what is the procedure adopted?
procedure, my lord, perhaps that goes up to, my lord, state election commission,
no.
panchayat.
When the complaint is filed against a member for disqualification, what procedure the deputy commissioner is supposed to adopt?
I think
Minimum.
complaint is lodged to the member secretary. If member secretary proposes to the
Proceedings.
proceedings, my lord. Proceeding, my lord, obviously, my lord,
What
notice,
procedure is adopted?
my lord, the procedure is CPC, my lord.
At least minimum.
Minimum,
has
yes.
to be.
CPC, my lord, yes.
Well,
Summoning and production documents, my lord, yes. Under CPC. my lord.
After just before the two lines, the last sentence. Interim order is before that, That a part. The deputy commissioner appears to have not followed even a minimum procedure for proceedings of disqualification under the Act, which is the minimum requirement of the law. Then you just
Item number 6 and 7 are dicto scan copies like others.
same.
Only thing I will provide the constituency.
Name consistency will be different.
In item number in respect of D, it will be C.
4 weeks. Call for the records. List after 4 weeks.
Obliged, highly obliged.
Caveat the chairs. Hard so and so, Mr. Gara, keeper. Deputy Commissioner has might, I mean, on off the record,
Yes.
has given a cliffhanger to the petitioner.
I have,
I told him the reason why the lordship has stayed. I'm going to tell him again now.
Your Lordship, I have,
I know.
Off the record, on a lighter note.
all the records have been brought before the.
Not handled, cliffhanger.
Technically, what they have not done. That is the thing.
But it has not.
I
been-
purposefully using the word cliffhanger. Yes, sir.
May I please, Lordship? Lordship, here in this case, Lordship, respondent number 5, the executive engineer has.
Where is the last order? Have you annexed that?
Yes, Lordship.
Where it is? What is the order, this thing? The
Subject to the outcome of this.
work is what?
Work is with regards to, Lordship, that is approach road from BRO helipad Lille to CO cum video office under Surly Township.
Where it is?
Lordship, page number 22, annexure B,
22.
Lordship.
NIT.
Lordship.
Was it not published in the paper? Or the
This is a e-tender, Lordship. It was uploaded in their portal.
where is the impugn order?
Impugn order is page number 36, Lordship.
36.
Yes, Lordship. Lordship, first page, page number 36,
This is the same order.
Lordship, same order.
Then you write page 99, same order. Or Mr. So and so. Titable and counsel for the petitioner. Petitioners
Yes, Lordship.
and also had Mr. Arichanabam, learned additional advocate general for all the respondents. Same order will pass same order today. We'll issue notice and pass the same order. This NIT is which date?
Lordship 22
or 21? Where is the date?
That is impugn order, Lordship. This is impugn order. NIT was
No, NIT, I'm asking NIT.
21/3.
Same date.
Yes, 21/3/24, same day. Yes, same day, Lordship.
Then you just page 19, right? You just challenge made in this writ petition. A challenge is to the office order dated 22/05/2024, passed by the executive engineer, Sangram Division,
Lordship.
PWD. Whereby the NIT dated 21/3/2024. Issued for construction of approach road from BRO helipad Lee LEE to CO cum BDO resident via hospital / general ground / CO cum BDO office under Sandy Town has been cancelled. Then you read almost the same thing. Issue notice. Same order, Issue notice returnable by 4 weeks. Arrest Nabum so enters the so considering so. List after 4 weeks. Along with WPC,
Yes, Lordship.
along with WPC 438 of 2024. That page 99, same in the same impugn order, same order will be. Yes. So that yes, that we have considered in the other case that there is no provision of the banning of issuance, particularly a cancellation. It can be postponed and you can complete the process.
Yes, Lordship.
There is no bar as such in the MCC. That's the reason. What this?
Lordship, the impugn order may be stayed.
Yes, same order.
Yes.
438.
Yes, Lordship.
Same order.
Deeply obliged.
Madam, you have understood page 99. The name of the lawyer is same, petitioner. Respondent will be Aris Nabur. NIT same, impugn order same. Only the construction of the thing, work is different. That's what. You find it out. Item number 4.
I've got the.
Why you are in a hurry? We said that two. We'll take it away at 2. Wait for your turn. Want to rush? Want to go somewhere else?
Yes, my lord. I've got some work, my lord.
Where?
Uh,
What 2 hours?
My lord, promise, my lord, nothing remains, my lord. That's my lord already. It is a covered case, my lord. But
You don't have to come in that case.
my lord.
Go to Deputy Commissioner and say it's a covered case.
No,
Give me
no,
the same-
I have already with the representation, but then no action whatsoever has been
Where you
taken.
want to go? Where you want to go now?
Now, my lord, I'll go back home.
So don't go back now. We'll take up your case at 2 o'clock.
My lord, always, my lord.
I thought you had some urgent or emergency. Okay, then it's okay. Yes. Yes, sir.
May I pray for disposal of this petition here?
No affidavit. What is your stand? Sir, correction of date of birth.
Second of the petition is considered. But at the age of 2 years, you were in class 1.
You file an affidavit. Why you are not filing it? Or will allow you to correct the date of birth?
No matter. That is the serious objection made by the manager.
Third, Mr. Aibam, learned counsel for the producer, Mr. M. Kato, learned deputy solicitor general, DYSGI is granted further 3 weeks time to file affidavit.
They have filed.
You have filed?
Yes.
Okay.
And affidavit is replying to also filed. So whether
Okay.
we admitted or didn't.
No, in the court's record, it says additional affidavit not yet filed. What additional affidavit?
No, additional affidavit in regards to your lordship, the mark sheet of the petitioner was supposed to file, your lordship. But your lordship, it is not necessary now because in mark sheet, nothing to do
Correction of the date of birth.
Hmm.
Only thing is, but if date of birth is corrected, he will be ineligible to sit with the examination at the age of 10 years in class, 12 years in class.
So what is the,
No,
what is your
Lordship,
age? No.
Your lordship, in that case, your lordship, he was passed from UP, Uttar Pradesh, and there was a judgment from the Honorable High Court that the minimum age should not bar appearing the matriculation. Lordship. There is a judgment, and I have made a specific abatement in my affidavit in reply. So
as per the class 10 certificate,
yes, Lord.
this is correctly entered the date of birth.
No, your lordship, it is not correctly entered, your lordship.
Where is wrongly entered it?
Wrongly entered.
Service book or in the class 10?
Both, your lordship.
Both we cannot.
Your lordship, I have obtained my birth certificate from
Her IBAM, learned counsel for the petitioner, and so and so. Huh? Pleadings complaint list for admission after Puja vacation.
the petitioner was supposed to retire on 30th August. Now, why now he is retired again, your lordship?
Enjoy the evening of your life. Why unnecessary?
Your lordship,
If the date of birth is wrongly recorded in class 10 and service book, how can it can be corrected? On what basis it
Yes,
should be
as
corrected?
per the guideline, if the government of India notify the notification whereby date of birth in the service record can be corrected. I have annexed that document. Your lordship,
In
and
that case, I mean, that will be strange.
Your lordship,
Everybody who doesn't want to retire, they will get it corrected.
no, your lordship, that
What is the basis of your claim? Forget about that government of India.
basis,
Which correct date of birth is recorded in which certificate,
your lordship,
according to you?
my
Nowhere.
no way. But I have obtained my correct date of birth from the registrar, your lordship.
Which registrar?
UP, Uttar Pradesh, birth in sir.
Uttar Pradesh is a big state.
Yes, Lord. And in as per this guideline, your lordship, those documents can be validated, your lordship, in order to rectify the date of birth. My case is very simple, your lordship, as per the guideline of the
But
government.
for this court is very complicated. Therefore, next,
Your lordship.
immediately after the puja vacation.
Yes.
All right.
All right.
But you have to fully prepared.
Yes.
Yes, Mr. Kato, what is this?
The date of birth cannot be corrected except by which he will be disqualified to appear in the examination.
Forget about that. You have your own policy. There's a guidelines.
Guidelines is with respect of the correction of the birth, always there is a provision for the correction of the date of birth.
Yes.
But if the date of birth is corrected, he will be ineligible.
So that's on that he's saying that he was permitted to appear in the exam by the High Court.
Permission is with the parent. permission cannot go beyond by which, he will be rendered himself free. That is the final law. Otherwise, final.
In that case, you write last, third so and so, so and so, writ petition is admitted for hearing. List the matter after, immediately after puja.
Matter may be admitted for hearing. And in fact, my lord, the pleadings are completed.
Which one? We'll close that. Having been. We'll close the revision.
My only contention is, my lord, without my lord, following the due process of law, my lord, the cancellation of the LPC is, my lord, arbitrary, my lord.
No, he said it has become.
No, my lord. It become infractions in that sense, my lord. After cancellation, village level keba was held, and in village level keba, the title has been decided in favor of the private respondent number 5, my lord.
Yes.
Which we are assailing before the, my lord, the civil judge, senior division, and that is under process, my lord. Admittedly, my lord, that is pending to decide the, my lord, issue whether the ownership, my lord. But here, my lord, my specific contention is.
See, the title has been already decided in favor of the respondent number 5.
Correct, man.
What's the question of LPC? LPC has become redundant, legally or illegal. LPC issued to a owner.
Correct.
Is not it? You claim to be an owner, therefore LPC was issued wrongly or rightly.
Yes, ma'am.
Now the title has been decided by the appropriate forum.
Mother.
There is put to challenge. You pursue that. There is nothing. Even if today, if we hold that the cancellation was wrong,
well,
the procedure of cancellation was wrong or illegal, what relief can be given to you? It has become redundant.
That must only, my lord. The other, my lord, the steps, my lord, regarding she has rightly instituted for the, my lord, the claiming of the titles over the land, my lord. That is, my lord, correct for provision, my lord. But the of the, my lord,
no, unless you have the right and title of the land,
my lord.
Even if the cancellation is held to be wrong or illegal,
yes, my lord.
What relief can be granted
my lord,
to
that
you?
much only, my lord. The cancellation
Because
of the, my lord, is irregular, is
is
illegal, arbitrary, my lord.
Futile exercise.
My lord, because of that reason, my lord, the title should has been instituted before the village level authorities.
That's why you
had it been the case that, my lord,
you have challenged that before the appropriate one. You pursue that only.
that is, my lord.
This has become not infraction. This has become redundant.
Yes, my lord. In fact, my lord, my submission is on the last occasion, my lord, this matter has came up before your lordship for on several occasions, my lord.
Yes.
Yes. That was the my lord, my whole contention, my lord. Had it been the case that, my lord, if 2 LPCs issued in my favor is not cancelled by the, my lord, authorities concerned, but more particularly ADC, my lord, the titles would not have been initiated, my lord. So because of these reasons, my lord, after cancellations, my lord, the title, the complaint was made before the village authorities, and the village authorities, without giving me an opportunity, even that is not a village authorities in fact in a strict sense, my lord. But that will be decided by the, my lord, the
It is
FLS
a
court.
subject matter of the
Yes,
civil court.
that is already pending before. My lord, to that extent, my lord, only, my lord, that my lord, prayer is the impugn to cancellation order, the cancellation order issued by the, my lord, the deputy, additional deputy commissioner may be interfere with me.
No, it may, that cannot be done.
My lord, it's because, my lord, if my lord peruse the, my lord, the order, it is not as per the procedure prescribed by the state government for issuance of the LPC, my lord. Had it been the case, then, my lord, if regular proceedings is my lord, the process and then, my lord, I could have been in different position, my lord. So therefore, my lord, if lordship peruse the, my lord, the impugn order, my lord, the things which has not been at all, my lord, to be done by me cannot be, my lord, enforced me to do, my lord.
Where is
It
the
is
impu-
out of my
where is the
control.
impute order?
My lord, is more particularly, my lord, may I take your lordships to the impugn order passed by the additional deputy commissioner,
28-9.
page 23, my lord.
Yes.
My lord, for issuance of the, my lord, the LPC, is still, my lord, the state government is following the format, my lord, standard format prescribed by them only, my lord. And as per the prescribed format, my lord, we are following the, my lord, the procedure. And we are submitting the, my lord, the documents as sought for. Para 9 more particularly, my lord. May I read, my lord? This office has perused the official records of the process of issuance of the LPCs and also compares with the annexures and attached by the complainant, Srimati so and so, alias so and so. It is revealed during the statement that Srimati so and so was not aware of the entire process of the issuance of LPC and that non-issuance of notice to Srimati so and so, private respondent number 5, suffers from irregularity and in violation of the principle of natural justice. And it may be noted as such that the LPC application spam does not have any provisions in the format for notice to espouse for inspection and the written objection. It is also findings of the learned additional deputy commissioner. Then there is no prescribed format. And it is also pertinent to mention that both had purchased the land in the year 2006. But Sri so-and-so petitioner alone got the LPC issued for himself without any acknowledgement to Srimati so-and-so, alias so-and-so, so-and-so, and also mentions the second hearing about non-interference from her on the said land, which also indicates that Srimati so-and-so, so-and-so had right over the land. My whole contention is, when there is no provision as such, where in the prescribed format, nothing has been given, it cannot be expected to do the persons who applied for the LPC. If the applicant violated any of the provisions prescribed in the format, then admittedly that is one ground for cancellation. She has found out the flaws which is not at all prescribed in the format. So therefore, may I take your lordships to the LPC format. This has been prescribed by the state government, not by me. What we have to do is only fill up the form in the application format.
Yes, where it is.
It is Annex 3, page number 27. Still, these formats are being followed by all the applicants who intended to obtain.
Is there any provision for cancellation?
But my limited understanding, no, there is no provision adjustment. If I have violated one of the condition precedent, and in the stipulated terms and conditions, then the cancellation would have been in a different aspect. But the procedure not at all prescribed. Even if notice is to be issued to the spouse, it is not my duty, and notices are not being issued from my side, It has to be issued from the additional deputy commissioner, who is supposed to issue notice or the LPC.
And my lord, my other summation is, even if,
According to you, since there is no provision for issuance of notice,
correct, my lord. That is the only, my lord, my case.
notice means what?
Notice,
Opportunity of hearing.
opportunity of hearing for
It is not to be always
objection, my lord.
No, no.
If
it
there is any objection, my lord.
We can read into it. We can read into it any proceedings, if necessary. We'll have to read into it.
My lord. And notice
It
format is also,
always implied.
admittedly, my lord, notice is also prescribed, my lord. Even there is no, my lord, the other, my lord.
So it is not necessarily to be expressly provided.
Expressly provided, my lord.
It is not required. It is not required to be expressly provided.
My lord.
Can be always read into. I think that is what I have recalled. Therefore, heard Mr. M. Kato, learned counsel for the petitioner, and also heard Mr. Estapin.
3 and 4, my lord.
I am for 1 and 2, my lord.
1 and 2. Mr.
Especially-
Especially. And 3 and 4, Estapin, senior member, and Mr. Patil for respondent 5. Pleadings are completed, admitted for
My
hearing,
lord.
list after 3 weeks. After the
My lord,
petition.
it may be disposed of today, my lord. Well, because otherwise, my lord, this is supposing
Let him take a chance.
in that case, my lord, supposing as your lordship had rightly pointed out, if this writ petition allowed, first thing is that it would amount to negate the proceeding in the court below, customary court. In
That to the
no,
legitimate aspect
then
of whether
no, my lord.
for issuance of LPC, whether a notice is required.
Yes, my lord. I have, in fact, on the last occasion, I have submitted a copy of that notification.
Yes, I have seen it. That's the reason I'm.
Yes. So even the clearance from the respective departments are required. And your lordship,
But the cancellation has not been done on that ground.
my lord, that not only on that ground was in paragraph 4 of their affidavit in opposition of the respondent 3 and 4. It categorically stated that this was obtained by suppressing material facts. And secondly, no notices were issued. All the cell letters are in my favor, but I have not been given the opportunity. So those are the specific stand. And my lord, if such things are found, I have made a complaint that these are not as per the procedure. It was found, and these LPCs were recalled, and recalling of LPC is permissible if it is found. My lord, I have the judgment. 1994. So paragraph 8. My lord, pendency of this petition.
Sir, let us give him one more chance.
My side my response submission is, my lord, pendency of this writ petition. Otherwise, this is a disputed question of facts. He is claiming that it then is his.
No, that's why I have observed.
That's my why I'm seeking urgency, because pendency of this writ petition in other sense it's affecting the entire lower parts, because this writ petition directly does not deal with the subject matter of the customary court or the civil judge, but then at the end of the tunnel there is a knowledge that yes, this is pending, what we'll do, all that.
That's why immediately after the puja case.
Well, in that case, a fixed date, my lord, on 23rd, and LCR may be called for,
23rd.
23rd, LCR may be called. Well, LCR is not required.
All
the records are here, my lord. They are already annexed.
So are you saying that the notice was issued to the respondent?
No, my lord. Admittedly, no.
Before issuance of LPC.
No,
before granting
Admittedly, my
LPC,
lord.
notice was issued.
My lord, it is even not within.
They are saying that no notice, nothing.
It is not within my knowledge, my lord. It's because there is no procedure for, my lord, issuance
No, they have filed an affidavit
Yes,
saying that no notice was issued. Instead, the authorities filed an affidavit saying that no notice was issued.
Yes, ma'am.
You have not filed any reply also.
But in that case also, my lord, may I pray the my lord,
23rd.
23rd, my lord. And
No
adjournment, my
LCA.
lord.
No LCA.
Well.
No record is required here. In fact, this all become, I think.
My lord, one statement, my lord, in the affidavit filed by the state, they are saying that, my lord, there is no record available in the office, ma'am.
It will become only purely academic. Because ownership has already been decided, title has already been decided. You are pursuing that case.
Yes, ma'am.
You filed an appeal against that. Anyway, 23rd.
Deep level. No, 23rd. May I, Lordship?
Yes.
Yes, the private respondent has already filed their affidavit.
Yes.
But there is no affidavit from the government.
Yes. What is your submission?
Some time may be given to file reply on the affidavit filed by the.
Use the mic and little loud.
Some time may be given to file reply on the affidavit filed by the
Mr.
private respondent, Mr. B. Padum.
Learned counsel for the petitioner. Press for it is granted 3 weeks time to file affidavit in reply. Anything?
You have not filed out counter affidavit, Your Lordship. At least
Uh,
4 weeks
uh,
time may be given. Your Lordship.
Affidavit in reply to the affidavit filed by the respondent number 3.
Three.
Yes. In the meantime, state is also granted. In the meantime, the state may also file the response.
But interim order may be continued.
Interim order process will continue.
No place.
Lordship, this is state appeal lawsuit. State appeal lawsuit.
Yes.
Yeah, Lordship,
Is it listed for the first time?
no.
Then
It's being listed for the third time now. On on 21st March lawsuit, direction was given to go for a joint lawsuit, measurement lawsuit. Accordingly, measurement has been done lawsuit. In the impugn order lawsuit, the interim order granted by the learned court below lawsuit. This is pertaining to constructions of a mini secretary at Daporiji lawsuit, the Upper Subansiri district lawsuit. There's a phase 1, phase 2 lawsuit. The phase 1 was lawsuit that was awarded to the present the petitioner lawsuit, applicant before the learned court below lawsuit. Now we are lawsuit going ahead with our phase 2 lawsuit. NIT was floated and even the award was given lawsuit. Now against that NIT, they filed lawsuit application under section 9, whereby lawsuit interim order has been granted against the NIT, second NIT lawsuit. So against that order, we are before this Honorable Court lawsuit.
what happened to this interim order?
Lawsuit.
After the interim order, what happened?
After interim order lawsuit is directed by this Honorable Court lawsuit on last occasion. In interim order also lawsuit. The parties have been directed to go for the joint verifications. So for the extra works executed by the applicant dear lawsuit. And in the middle lawsuit, the second NIT has been stayed lawsuit till the payment has been made lawsuit. Then we appeal this appeal before this Honorable Court lawsuit. And this Honorable Court also by order this particular 21st August March lawsuit. Lawsuit order for joint verification lawsuit, joint measurement lawsuit.
Yes.
Accordingly, joint measurement has been done lawsuit. Measurement has been done and report is available also.
So
now the for the extra work lawsuit, executed by the contractor lawsuit, the petitioner in the learned court below lawsuit. That part has been already quantified by this remeasurement lawsuit. Now, when the quantity has been lawsuit, there has been quantified lawsuit. The amount can be lawsuit paid, and that issue can be settled later on lawsuit. But so far, the stay of the second NIT, which is a completely different from the past NIT lawsuit, that stay lawsuit, we are agreed by that stay of that second NIT lawsuit. So we are basically on that very lawsuit issue. That why lawsuit second NIT has to be stay lawsuit.
No, after the joint measurement by parties, the appellant shall proceed to the execution of tender dated 09/10/2023. This is the second NIT. 09 is the 2023.
Second NIT.
After 15 days, which yes, no, you have not been stopped or restrained.
The order of reasonable.
Yes. 21/3, 21st March order.
So actually,
do you have that?
Actually, I have no.
I'll just read there.
No, sir.
After the joint measurement by the parties within 15 days, the appellant state order shall proceed with the execution of the tender dated 09/10/2023. This
No.
is the second NIT.
No, sir.
Then,
Correct.
who appears for the respondent?
Mr. Naya was the lawsuit.
Okay.
But the issue is here lawsuit. Actually, I was not aware about that particular direction lawsuit. So for direction for remeasurement, that is already noted here lawsuit. Mr. Ratan was appearing
After 15 days,
yes,
you are allowed to proceed.
but the difficulty is here lawsuit. They are not handing over the lawsuit site lawsuit.
What is any notice to the any notice to the respondent? Notice.
I think on last occasion they already appeared lawsuit.
There is no office note when the notice has been served.
21st March order, I think Mr. Naya appeared in this on that particular day. In his presence, only this joint measurement order was passed.
Yes.
Denial also.
So what went today? Everything is given to you.
Lawsuit. But they are not handing over the lawsuit side.
That we cannot do. But Mr. Estafin Learning Council for the petition. Not appears for the respondent number 2. Although on the last occasion, Mr. P.D. Nair, Learning Council appeared for respondent number 2. Then what is to be done?
Then 22nd lawsuit.
Further 2 weeks time is further opportunity of 2 weeks time is granted to respondent number 1 and 2. Or no, further 2 weeks time is granted to the respondent 1 and 2. Mr. Cornell list this matter on
23rd.
23rd.
October.
Strange.
Most of it.
I did not understand what you have submitted.
Lawsuit?
I did not understand what you have submitted.
Lawsuit. Because that part lawsuit.
That's why I got blank.
Actually the part of that last order, the copy is not printed and I didn't appear. Mr. Ratan was the lawsuit. So when that part has been read out by this lawsuit, then I got confused.
You got confused and you made this court more confused.
Lawsuit. Sorry, lawsuit.
It's okay. Yes.
But a notice was issued way back on 25/6/2024. No response, nothing. If your lordship may kindly have the impugn order at page 32.
Yeah.
Very minor, the perusal of it would be enough to interfere, madam. Indefinite suspension.
Yes.
No review, nothing.
My lord, admittedly, review not done. As per instruction.
And till my lord trial, my lord, no charge sheet, nothing.
Where is the dispute order?
Page 32, my lord.
This further order during the period of trial, this order shall remain in force and the
It is further ordered that during the period of trial, this order shall remain in force. No review, nothing. Trial has not even started, man.
What trial? That criminal trial?
Yes. There never may be a charge sheet, who knows? 19th of February.
Can you pass the order like this?
My lord. My lord, it should have been.
10 is clearly violated. Rule 10.
10-6.
Yes. Review before 90 days.
Yes.
My lord, it's a fact that
Submitted
they have not
appellant
been
review.
the suspension order has not been reviewed. In all
Cannot be reviewed because you,
Yes, not
you
really.
because
Yes.
because that it cannot.
you have provided that it will remain
There's a
for
technical
entire trial.
well, there's a technical defect, man. That's because of that.
So you cannot do anything.
My lord.
Or Mr. Deepang, counsel for the petitioner. What is, these are all analogous matter one.
Yes,
All analogous matter.
one order will do, man.
And Mr. Tita, counsel, Stanley counsel for
Education department.
Department for respondent number 1, 2. For all, huh?
Yes,
All
ma'am.
respondents. By filing this red petition, the petitioner has put to challenge the order dated 19/02/2024 passed by the commissioner. What is this?
That's instruction I've just received for petitioner.
Yeah.
What do you mean by the review on suspension order and discipline is yet to be covered up? What does
Yes.
it mean?
My lord, review not done, only that.
Whereby the petitioner has been placed on, by which the petitioner has been has been placed on suspension with effect from 09/02/2024. We'll continue in the chamber. Read petition allowed?
My lord, no.
We'll settle at the that. To pass the order.
Problem.
13, 14, 15, 16.
Yes.
Same order.
Same order.
Same.
Same order.
Different
same
name, my lord.
Only the
Different
petitioner's name and the post will be different.
Okay, but otherwise it's a
Yes, yes, exactly. Problem.
verbatim.
Illegal appointment.
It's verbatim.
My lord.
Orders are verbatim
Yes,
for all petitioners.
yes. Ex-
Same case,
Yes, yes.
same
Yes,
arrest,
Yes,
same
yes,
day of arrest,
yes.
same day.
Yes.
Same allegation.
Yes. Arrest notes, everything.
My lord, my friend here, my lord, is yet to file his affidavit, my lord.
Yes.
I'm praying some more time, my lord.
Mr. Disqualification learned consent for the petition. What is the matter?
My lord, here my service condition, my lord.
Okay.
It has been altered, my lord. Now, because I was a AFA junior, my lord. My promotional post ought to have been AFA senior, my lord. Now I was without giving any opportunity. Mechanically, they appoint me as AMI, my lord. The
Is it
assistant.
promotional post or what?
No, my lord. Till that for that AMI, there is no rule as well as also, my lord. Not the post, my lord. How the recruitment is to be made for the AMI, there is no rules as such, my lord. Now what has
You
happened?
initially appointed as assistant.
No,
Assistant-
AFA junior, my lord.
AFA
Agricultural field assistant junior, my lord.
Thereafter, while you were working as a junior,
Yes, ma'am.
AFA junior,
Yes, ma'am.
you are appointed as AMI.
AMI, man.
What is AMI?
Assistant marketing inspector, man.
Yeah. There's
So
no
my-
post. It's not a career post.
No, my lord.
It's
My
not
lord, so
career
posts have been created, my lord. Yes, my lord. But till that, no rules as such has also been framed, my lord. I am languishing there, my lord. But my juniors, even my juniors, they have been appointed as the AFA senior, my lord.
senior.
Picked and choose,
In a
my
higher
lord.
grade, higher pay scale.
Yes, my lord. Higher, and they have further promotional avenues, my lord. But as for the AMI, my lord, we have nothing, my lord. We are just stuck there, and even our counterpart,
When
my
you
lord.
were appointed as AMI,
2004, my lord, of course, my lord.
what is it according to you? Is it higher? You were getting when you were appointed
My lord.
as AMI,
My lord.
were you paid higher scale of pay or some higher?
No, my lord, not
more
as such, my lord.
benefits
No, my lord.
than
We
the
were, of
AFA
course,
AFA junior.
yes, similar, my lord. We were told that it is a promotional post, my lord. But since these persons, my lord, they are basically posted.
2004. What
Of course, of
what
course,
you were doing?
of course, my lord, it is there, my lord.
Anyway, because
Yeah.
this of London Council for the petition.
My lord, may
The London Standing Council, Agriculture Department. Press for and is granted 3 weeks further time to file affidavit.
April may listed for on first week November and this last chance, my lord, because the petitioners they are, my lord, retiring, my lord. One is
Last-
already aged 50.
My lord, this is listing for last chance would be very dangerous for me, my lord. And my lord, no, my lord. Ultimately, I need to take before filing, my lord. Betting of law department also required, my lord.
No,
Because this was filed in July, my lord.
Do it 3 weeks. You have 3 months, sorry, 1 month, 30 days time, enough time.
Last chance, my lord.
Since considering that the petitioner is due to retire,
Already 59, my lord.
due to retire, would be, no, sorry, considering that the petitioners,
Yes, my lord.
Petitioner.
one,
Two, my lord.
two,
Two petitioners, my lord.
petitioner would be retiring. Retiring should come up. The state respondents, Mr. El Permelan, counsel for the London State Council is granted the above 3 weeks as a last chance. Then you will be activated.
That's right.
First week of November, then, my lord.
List the matter on 10th.
Anything, my lord, yes, my lord.
No, just
10th
first
or-
week, just see.
First week, my lord. All right.
Yes.
God bless.
What is this? Contempt?
Yes, your lord.
What is to be done?
Respondent number 9 is yet to file their reply.
My lordship, I am for the respondent number 9, that is Deputy Commissioner. That
9?
Yes, my lordship.
Yes.
That I need some more time to file affidavit.
Okay. What about the others?
Respondent number 7, they have filed the reply.
Okay.
So only 2 respondents who we have served the copy.
Heard Miss MS so and so learned counsel for the petition. Mr.
J. Modi.
Learned counsel for list contempt number 9. Respondent is granted 2 weeks time to file affidavit.
Your Lordship, I would refer to matter will be fixed on 11th of November.
Listed on
11th November.
11/11/2024. List the matter on sir.
But here I am for the sole respondent, madam. But we have already complied with by depositing the amount, madam, as directed by this.
So closed.
This matter may be closed.
Heard Miss MS so and so learned counsel for the petitioners. Petitioners.
Yes.
Mr. M. Kato, learned counsel appearing for the respondents, submits that the order of judgment and order, what is that? Page
30th January 2024.
page 19.
It's in page 19, yes, sir.
30 judgment and order dated 30/01/2024 has been complied with. Mr. Complied with, the submissions which the learned counsel board petitioner has also accepted. Mr. In view of the contempt petition is still closed and disposed of.
21.
Yes.
As per the office note, service upon
Service
upon respondent 4, 6, and 7 is still awaited.
Upon respondent
4, 6, and 7.
4, 6, and 7. For the 3 weeks. List after
Your
3 weeks.
Lordship, 2 weeks at least, immediately after the break, Your Lordship.
What is this?
Because there is this interim, Your Lordship.
What is this?
The NIT has been stayed, Your Lordship. The NIT has been stayed, Your Lordship.
For the 2 weeks in that case.
Sure.
Oblige.
Oblige.
22 and 23.
My lord. At number 22, my lord, 22, they filed the IA for vacation of interim order. And at number 23, my lord, is I'm challenging the transfer order, my lord, subsequent modified transfer order.
Yeah.
Initial transfer order, my lord, it was issued on 17 July 2024, allowing the petitioner to remain at the Nari division till the superannuation. He's getting retired on 25, my lord, January 25. And in the despite of this order, my transfer order issued in my favor, there's no problem. Now, subsequently, this transfer order was modified, whereby it was directed to assume the private respondent immediately take a charge, my lord. That is why this has been this writ petition has been challenged. Now, under the relevant policy guideline transfer and posting, there's a specific provision that officer who is at the verge of retirement is not to be transferred at the verge of retirement, even if it is required to be transferred on administrative exigency. He has to be transferred before 1 year. That too, if he is posted in particular in the field, he has to be posted in the headquarters before 1 year.
It's a guideline,
Yes, a guideline.
not enforceable.
Yes, now here, when the petitioner is left with hardly 5 months to retire, this modified transfer order has been issued. Now hardly 3 months left for retirement, man. That is why, my lord, now there's no
List after 3 months.
No, my lord, this is the entire matter may be disposed of.
even my respectful submission. In such cases, my lord, even this bench, this honorable High Court has also held that in case of just retirement, the 2-3 months, 5-6 months is left, man. It will not serve any particular any practical purpose. In that case, my lord, that transfer order has been interfered with on the ground that when the employer is retiring hardly 5 or 6 months, why there should be, it is just the unnecessary, and it is the transfer order would not serve the practical purpose. There has been the decision in this aspect also, and similar to this case, my lord. Likewise, that's why, my lord, in my respect.
Lawsuit is a guidelines lawsuit. It says lawsuit when it's likely to be lawsuit, superannuated lawsuit. Within 1 year lawsuit.
Because he's now, when the order was passed, he has only 5 months.
Yes.
Now 3 months. We'll list this matter after 3 months.
No, my lord,
You wait for your turn.
My lord, it's of course, my lord, now Florida has a start one, my lord.
Yes.
Let us, my lord, discuss this matter today.
We'll resume it too.
Well,
Same order,
My lord.
12-2,
12-2.
12-2-2021.
Yes, my lord. My lord, I filed a representation also, my lord, on 12-9-2024, my lord, but that has not been added to, my lord.
Yes. Madam, where's the impugn order?
Impugn order, my lord, will find at page number 81, my lord, or 181,
181.
my lord.
This is 28. So your names, all this.
No, my lord, the petitioner number 1 is placed at serial number 69, my lord, at page 184.
$69.
69, my lord, serial number 69.
Yes.
Oin Paron, my lord.
Hmm?
Oin Paron. He is the petitioner number 1. Yes, my lord.
So all these
The
earlier writ petition by some of the
Yes, my lord. Similarly situated persons, my lord.
license holders
Yes, my lord.
by the same order.
By the same order, my lord. My lord, here, my lord, in fact, earlier, my lord,
Wrongly recorded. It is wrongly recorded.
in fact, my lord, the present, except for the petitioner number 1 in the instant case, my lord, the other petitioners, the 20 other petitioners, they were not summoned, they were not issued any order, my lord. But our license has been taken back, and then it has not been renewed till that.
The license have been revoked or renewed?
It has not been,
renewed.
there is no order as such, my lord, but then we have already given back our license to the respondent authorities, my lord. But then they are not still renewing their arm licenses, my lord. Purportedly, my lord, because of the order, that purportedly because of this impugned order, my lord.
This order was put to challenge.
Yes, my
In
lord.
the early
Yes, my lord. And the blanket ban, which was issued in 2016, my lord, which my lord will find at page 1888, my lord.
I think there is one more petition.
In fact, my lord, 70 persons came, my lord. In the earlier order, my lord, 109 persons were issued, my lord. And thereafter, 97 other licenses were issued, my lord.
Issued?
Yes, my lord. In 2019, my lord.
Let us see that order of this court in the batch of
My lord, my lord. Page 202, my lord.
Yes.
My lord. The opposite part would be from 2 to 4, my lord. There are 13. May I read it, my lord?
Yes, yes.
In the circumstances, we are of the view that the interest of justice would be met on the direction being issued to the Commissioner to the Government of Arunachal Pradesh in the Home Department, if necessary, to verify the records available with the department as regards issuance of arm license and up to verification of the records. If it is revealed that any individual case, the arm licenses were issued either illegally or to an undeserving person or in contravention of any of the provisions of the Act of 1959 or rules of 2016, individual notices may be issued to such persons and appropriate action may be taken by the authorized authority under the Act of 1959 and the rules of 2016. By scripturally following the procedure prescribed in the Act of 1959 and the rules 2016, more particularly Section 17 of the Act of 1959. In view of the conclusion arrived herein above, the arm license that were already issued to the petitioners shall be restored back to them immediately. But again, if the authorities are of the view that any one of them is required to be subjected to the verification process or any further action as indicated above is required to be taken, liberty will remain to the respondent authorities to proceed against such persons as per law as indicated. In view of what has been provided, the arms license will be returned back to the individual licensees. All the individual notices or cancellation orders that may have been issued in respect of the petitioners stand, interfered, and set aside. It is however added that the petitioners to also not abuse the arm licenses that are restored to them and behave in a manner as required under the law, and if any further violation is noticed, the appropriate authority may take action in the manner provided under the law.
How many petitioners?
In total, my lord, here there are 21.
Yeah.
Yes, my lord.
All of them are here.
Yes, my lord, 21, my lord. But in the impugned order, only the petitioner number 1 is there, my lord. But in action of the respondent number 3 in not renewing the licenses, my lord, is because of the blanket ban and this impugn order, my lord.
No, this impugn order is in respect of petition number 1 only.
Yes, my lord. Yes, my lord. Yes.
The name of the petition number 1 is, the petition number is only listed here,
Yes, my lord.
not others.
Not others, my lord.
Others, what happened?
Others, my lord, we have submitted our licenses to the respondent number 3, my lord.
What they're saying?
But there is
In
still
in view of the blanket.
yes, yes, my lord. In view of the blanket
This is
order, my
something
lord.
else.
Yes, my lord.
Armed license issued by Sri so and so, then district magistrate are found to be illegal and invalid in contravention to blanket by the order of
Yes, my lord.
government or Arunachal Pradesh.
Therefore, my lord, those licenses were also issued by the same officer, my lord. Earlier, 109.
See, impugn orders in other case, the earlier proceedings were something different.
My lord,
It's not the same impugn order.
except for the petitioner number 1, my lord. But since there is an standing order from this honorable court, my lord.
Hmm?
Since there is an order from this honorable court,
Yes.
when there is a finding that the impugn order or the blanket ban could not have been elected by the state respondents, my lord, as it belongs to the union list, my lord.
No, when you are not, other petitioners are not in this list of, in the impugn order, how can we
But then, my lord, there is
presume that they are also been?
why?
the
Because,
license have been
my lord, the inaction of the respondent number 3 is purportedly because of the impugn order and the direction given by the Secretary Home, stating that there is a blanket ban on the issuance of armed license since 2016, my lord.
Yes, what do you say?
See, with this one in annexed to your lordship, the same order like this one before this in earlier with petition your lordship. Okay.
You can dispose it off. Are you saying that this is a covered case? Yes.
Yes, your lordship.
Is it covered case?
In my opinion, yes, my lord.
Yes, your lordship.
Sure.
Or your lordship, I will take instruction, your lordship.
My lord, there is an order, my lord, which says, but the similarly situated persons, my lord, they have been, their license have been allowed, my lord.
Dispose it tomorrow. Mr. Tapin, you go through the
And,
earlier
and
judgment
the
and-
order passed by the, my lord's order, my lord.
Yes.
It is in the same line, my lord.
It's not same order. Impugn order is different.
No, my lord, it's the same impugn order, my lord.
No, 12/12/2021.
21.
Yours is 28/12/2021. Different orders.
Yes, yes, my lord. No summons have been issued to the other petitioners, my lord. But the action,
No, this present impugn order is 28/12/2021.
my lord,
And this court has passed set aside the order of, the challenge on the earlier litigation is 12/2/2021.
my lord. Whatsoever, my lord.
Different orders.
Yes, my lord. But whatsoever, my lord, my case is that, my lord, since the arms and firearms, my lord, comes under Schedule 7 in Union List, my lord, List 1, item number 5 of the 7th schedule, my lord.
Yes.
It is under the Union List, my lord. And the state does not have the jurisdiction, my lord.
It's okay. That
Pass
will-
those
will
orders, my lord.
consider. What I'm saying is, this is not the same order. This is different order. Maybe a similar order, but then different orders. And your prayer is something different again. Okay.
No, my lord.
Prayer C. Yes.
Purporting to these impugn orders, my lord, and from the direction given by the state respondent, my lord, more particular.
Has it been set aside, all these orders?
Yes, my lord, in the
2016?
Yes, my lord.
19? Where it is?
Page 124, my lord. That's 224. In view of what has been provided, that the arm license will be returned back to the individual licensees, all the individual notices or cancellation orders that may have been issued in respect of the petitioners will stand interfered and set aside.
Where it is? Page
Page 225, my lord.
225. Devotee, devotee, all the individual notices or cancellation orders that may have been issued in respect of all the petitioners can interpret and set aside.
Need to review note. Islam is a license system. 19. And it, my lord, turns to page 222, my lord. Para 8, my lord. Of the order passed by this honorable court, my lord. May I read it, my lord? The Act of 1959 provides for a legal right to the citizens to have their request for an arm license to be considered upon the satisfaction of certain circumstances and the requirement that may flow from such circumstances. If there is any blanket ban of issuing any fresh license and there is a cancellation or non-renewal of the licenses issued after the purported blanket ban, we are of the view that the legal rights of the citizen to be considered for obtaining an arms license by following the due procedure of law under the Act of 1959 and the rules of 2016 would be infringed.
There's one more judgment, the order of this court.
Yes, my lord.
Apart from this.
Yes, my lord. That I have placed it there.
Not this one. Apart from this, there is another order. Do you have that?
No, my lord. I have placed the same one, my lord, which my lord has said that.
So you can dispose it of?
No.
Huh?
Because 2016 has been received earlier round of litigation. The blanket ban has been received.
Set aside.
So in this implement order, yes, I found that it is issued in terms of that blanket ban order.
Heard Mr. Opad, counsel to the petitioners, and also heard Mr. S. Tapit, learned senior government advocate, and MS P. Pang, learned counsel, learned state counsel. For all the respondents,
No. 150. Yes. 150.
having considered that the grievances raised in this writ petition is covered by the judgment and order dated 24/08/2022. Passed in a batch of writ petition, leading case being WPC number 420 AP 2021. And as agreed to by the learned counsel for the parties, this writ petition is disposed of at the motion stage itself. At the motion stage itself. Next paragraph. Challenge made is to the, where is that? Page, impute order
181, my lord.
185.
181, my lord.
181. That is 28/12/2021, issued by the Deputy Commissioner Pasigat, Isyang, Pasigat, whereby arm license issued to 109 arm license holders, including the petitioner number 1.
Yes, my lord.
Has been revoked. Mr. The petitioners have also challenged the order dated 02/09/2016 and 18/11/2019 issued by the Principal Secretary within bracket Home Government of Home and Commissioner within bracket Home Government of Arunachal Pradesh. Whereby a blanket ban on the issue of fresh arm license no, not whereby putting the blanket ban on the issue of fresh arm license and not an Mr. The petitioner have also petitioners have also prayed for a renewal of the arm license which they had submitted before the concerned authorities, before the Deputy Commissioner.
My lord.
Deputy Commissioner Isyang Pasigat. Mr. Which year you were given the arm license?
2019, my lord. At page 17 of my affidavit, my lord. I have made a table, my lord. Page 17.
In the impure order, date of issue is given. It's shown no 2017 and 18.
No.
No,
This
in
is only in respect of
petitioner number 1, my lord.
or petition number 1 only.
Yes. But petitioner, the
Other petitioners are not in the list.
in the list.
That's why I said they have submitted
No
their
summons.
licenses for renewal, but then the petitioners have refused to do that because of these orders. That is the point.
My lord.
That's why I said you are prayed for renewal.
Yes, my lord. My lord will find at page 17, my lord.
The petitioners granted armed license by the district magistrate, Asian district. In terms of the Arms Act 1959 and the rules 2016. In the year 2018 to 19, on a different date, in the year 2018 and 19. On the expiry of the license, the petitioner they have submitted for renewal of their armed licenses. It is contended that the petitioner, the respondents a respondent authority has refused to renew the same in view of the impugn order and the impugn orders that it's so and so, so and so. It is submitted by the, it is submitted at the bar that the order dated, the first two orders, 2016 and 19. Have been set aside and interpreted and set aside by this court in the batch of writ petitions within bracket supra list of. Although on except for the petition number 1, other petitioners are not in the list of revocation of arm license, but the impugn order in the impugn order dated 28/12/2021. However, the respondent authority has refused to renew the licenses of the petition number 1 to 21.
21, man.
Though their license had not been cancelled, revoked, cancelled or revoked, revoked or cancelled. Having considered the next paragraph, having considered that the present petition, the grievance is raised in this present petition is fully covered by the order dated, judgment and order dated
24/8/2022.
24/8/2022. Passed in the batch of writ petitions. Being WPC 148. Which is the leading case? 148.
148, madam.
148 of 2022 and others. And as agreed to by learned counsel for the petitioner. And learned counsel for the parties that the agreed to by the learned counsel for the parties. Come on. This writ petition is disposed of by setting aside the order dated 28/12/2021. Mr. In respect of the, we'll say in respect of the petitioner,
My lord,
petition number 1. We'll set aside in respect of the petition number 1.
my lord, my lord. But as far as the renewal is concerned, my lord, since the order itself is null and void, my lord, ab initio, my lord. All the subsequent orders or subsequent acts or deeds would
This is
be
before that.
illegal, my lord.
This is before that. The order was of 2012 to 2021.
My lord.
Joseph may say that Joseph, there cannot be a blanket ban as ordered by internal court laws, but each individual case has to be
We'll
considered.
not reiterate that since we said it's a covered case.
There is already DA, my lord, in the earlier order, my lord.
Accordingly, the impugned order dated 28/12/2021 is set aside, hereby set aside. Mr. It's not clear as
My lord, what I'm asking for is that, my lord, the order of blanket ban on issue of armed license has to be set aside, my lord, as it being illegal, my lord. And if it is set aside, my lord, all the subsequent orders will go, my lord. And the action on part of the respondent authorities, more particularly the respondent number 3, in not renewing our armed licenses, are the subsequent act which comes from that illegally banning, issuing an order of blanket ban, my lord. So once 2016 blanket ban order is set aside, everything goes, my lord.
According you delete that, huh? It makes last sentence, last line. According the since this court has already interfered with the impugn orders dated 16 and 19, huh?
0209-2016.
0209-2016 and
1810-2019.
1810-2019 and other notices and the notices issued to the armed license holders. In the above referred writ petitions. The Deputy Commissioner, East Siang District, is directed to provide the same relief as granted by this court in the said writ petitions. And to consider the applications when separate, different.
No, my lord, I have filed a representation, my lord.
File the representations, consider the representations for renewal of the armed license of the petitioners
12/9/2024, my lord.
in accordance with the Act and rules.
My lord. A direction may be passed by a specific direction to renew our armed licenses, my lord.
Consider and renew.
My lord.
Any application, it has to be individually filed before. When
Applications filed by the, because they have submitted the.
they will file an application for renewal.
No, we have.
Then in particular format.
As I said, in accordance with the Act and rules.
There is already, we have already submitted it, my lord. Obligation.
Yes. Just taking this. Yes. Let's listen. Unlisted. Yes, what is this? What is the matter?
Impugn order, my lord. Page 17, my lord.
17.
Yes, my lord.
Yes.
May I read, my lord? Whereas a complaint has been received from Sri Taing Kame, Vice President, Dugmi Au Society against Saji clan with regard to encroachment of Sidhu Sayan area at Monigao being claimed by Dugmi Au Society of Lugte area. Therefore, the following GVs or head GVs are requested to take up the matter and settle amicably on so and so at Kevagar, Monigao. By this order, my lord, Keba was also appointed, Keba members.
Keba members?
Yes, ma'am. Kajen Podo, Lingdung Hemi, Tanyang Yorpen, Iling Hodong.
It's fair. HGB, GB.
Malot, ADC Malot has taken cognizance of the complaint, Malot, and appointed Malot Kabang members, Malot, whether he has the authority. Malot. That is my issue, my lord. I say, my lord, after coming in force of civil court, he does not have any authority. ADC does not have any authority. He could have a better, my lord, refer the matter, my lord. But here he has taken cognizance of the matter, my lord.
It's too technical.
My lord, the order, my
But
lord.
he has not decided the matter, just a complaint was made. And as an executive officer.
He has constituted, my lord.
Duty is on the village authority.
My lord, referring the matter is a different thing and constituting a KABA members is a different thing, my lord. He has constituted the KABA and ordered to be KABA to be held on 25/9/24, my lord. Now, pursuant to that, my lord, this KABA page 26 my lord, has issued notice to me, my lord. Annexure 4.
Yes.
Sri Tasi Pujan, my lord, he is my lord, Chairman Saji Land Management and Welfare Committee, Saji Clan so and so. Whereas a memo number so and so dated Monigao, the 13th September 2024 was served to you in order to settle the land dispute between so and so Lungte area and Saji Clan of Monigao. However, you are evading the hearing process by not appearing before the KABA committee. It is hereby informed to you that non-compliance or deliberate evading from the hearing process shall be viewed seriously and an ex parte decision in favor of the Damigao shall be passed along with statement of the witnesses. Therefore, you are hereby directed to appear before the below mentioned KABA committee on so and so today, 3/10/24 at 12 p.m. at KABA. What I am projecting, is that referring a matter to the KABA and taking cognizance of the matter and cognizance of the complaint and constituting a KABA and appointing KABA members, ADC does not have any authority,
Who has the authority?
Village authority themselves has the authority,
Then
the private respondent has to file a complaint before the village authority, These village authorities are from different villages, May see page 17 again, Taje Podo, GB Didu, Lingdung Hemi, GB Karle, Tanyang European GB Karle, Helung GB Jerling.
yes. Mr. Bigam.
Lordship may have a look at this Amendment Act of the Assam Frontier Regulation, Your Lordship. As far as Section 4, Your Lordship. Amendment of Section 4. In principal regulation for existing entries, the following entries shall be substituted. Subject to the provision of this regulation, the Assistant Commissioner or the Deputy Commissioner, if the case may be, shall refer back the case presented before them to the concerned village authority for trial and settlement within the territorial jurisdiction of the concerned village or within the jurisdiction of its inter-village territorial customary court of apex customary court, as the case may be yours. If you see this, Your Lordship, the ADC is right, Your Lordship.
Yes,
my lord. That's why my case, my lord.
He has not decided, Your Lordship.
Referring
He has
the
simply
matter. Referring the matter and constituting KABA and appointing KABA members.
Shall refer back the case presented before them.
Yes, Your Lordship.
That is why, my lord. Referring the matter and constituting KABA.
They have presented the case before the respondent. They have presented the case before the additional deputy commissioner.
Yes, my lord. Complaint has been
and
filed.
it has been referred.
Not
to
referred.
the village authority.
By this order, my lord, the KABA has been constituted. My lord, may please appreciate page 17, my lord. KABA members has been, my lord, appointed, my lord.
This is GB, not a private persons.
Or they are not subordinate to ADC, my lord.
But then it provides that it said to be, can be. If
It can be referred, my lord. It can be referred, but ADC has constituted KABA, my lord, by appointing KABA members, my lord.
This way too technical.
How can ADC take cognizance?
What cognizance?
This amount.
They said whereas a complaint has been received from so and so.
Yes,
he has not decided anything.
My lord.
As
Now,
they
my
are
lord, yes, my
requested
lord.
to take up the
Therefore,
matter
my
and
lord.
settle amicably.
Therefore, following GBs and GB are requested to
GBs,
take up.
yes.
Yes, my lord.
What prejudice?
But by this order, my lord, they have. What ADC has appointed.
What prejudice will cause to you if these members are appointed? It's
my lord.
Head GB and GBs.
My lord.
It's not a private management. They are village authorities.
Even though, my lord, how can the ADC appoint, my lord, GBs, my lord, for taking up the matter, my lord, for taking up any complaint, my lord? ADC does not have any authority over the, my lord, this Gauburas, my lord.
We'll treat it,
GB
we'll treat it as a reference. He has not made any comment on the merit of the matter.
My lord, I would
Further,
like-
Kaba comments to ensure peace and tranquility during the course of case proceedings.
My
This
lord.
is fair enough.
This amounts to taking cognizance of the matter. My lord, I would like to refer one judgment, my lord. 2017 for GLT, my lord. I will read, my lord. I have
Yes.
para 28, my lord. May I read, my lord?
Yes.
In the case of Ritesh Tiwari versus State of Haryana reported in so and so, the apex court has held that if an order is bad in inception, it does not get sanctified at a later stage. A subsequent action development cannot validate the action which was not lawful as at its inception. For the illegality strikes at the root of the order. It would be beyond the competence of any authority to validate such an order. It would be ironical to permit a person to obtain benefits in violation of the law. In case of so and so, Apex Court in 2006 1 SSC 228, Apex Court has held that a right in law exists only and only when it has a lawful origin, my lord. Now, my lord, this Kabang proceeding, my lord, has no lawful origin, my lord. My lord, ADC, my lord, himself appoints Kabang members, my lord, and direct to initiate Kabang proceedings.
You read this.
I have that one. I've read this one.
Then
That amounts to only referring the matter. Here, the Kabang members have been appointed, my lord. By the
what
ADC.
Kaba
himself.
members? They are the village authorities.
Yes, my lord.
You show us they are private individuals.
No, they are GB, my lord. Yes, my lord.
GBs, then they are authorities. We will not go by name, by designation.
But-
They are village authorities.
But ADC has constituted, my lord, them.
Doesn't matter.
Whether the ADC has the authority, my lord.
He has referred it. Subject to provision of this regulation, the assistant commissioner or deputy commissioner, as the case may be,
That section is also vague, very vague.
refer back the case presented before them to the concerned village authority for trial and settlement within territorial jurisdiction, the concerned village or within the jurisdiction internal so and so. Are these Gaburas are not the Gaburas of this village, concerned village?
No, my lord. This issue is related to Lungte area, my lord. Now, my lord, this area is related to, my lord, at Monigaon. Now, these GBs are from Didu, Karle, Jerling, my lord. They are from different, my lord, village, my lord. My lord, may kindly appreciate, my lord. Referring matter to the, my lord, village authority.
Yes.
And appointing village authority for, my lord, for the proceeding of Kabang, my lord. It's a two different thing, my lord.
In my view, this is too technical a ground. And why 226?
227, my lord.
Okay. You have changed it.
My lord, yes, my lord, because of the observation of your lordship, my lord. My lord, may kindly state this, my lord. On the next date, my lord, this matter may be disposed of, my lord. Because, my lord, may kindly appreciate, my lord. Going to the village authority, my lord. Filing a complaint before the village authority is a different thing. Referring the matter is a different thing, my lord. And constituting a Kabang member is a different thing, my lord. And directing to, my lord, held Kaba on 25/9/24.
You did not appear.
My lord, yes, my lord, because this order has no validity, my lord. As per ADC has no authority, my lord, to appoint GBs, my lord, to conduct a Kabang, my lord. He can only refer the matter, my lord, before the Kabang.
mentioned Kabang on 12 p.m. at Kabang on Monigang.
Yes.
It's over already.
But even though, my lord, the proceeding has just started, my lord, the main order, my lord, whether it
Heard Mr. B. Pitcher, learned counsel for the petitioner. Petitioner only.
Petitioner, my lord.
By filing this revision petition.
Writ petition.
By filing this petition, the petitioner has challenged the memo number MNG oblique JUD oblique K-34 oblique 2021 oblique 323 dated 13/09/2024. Whereby the passed by the Additional Deputy Commissioner, Siome District, Moningo. Whereby the complaint of respondent number,
Private respondent number
respondent number
4.
has been referred to the village authority to settle the matter amicably. On 25 with effect from 25/09/2024. And also the notice.
Yes, my lord.
Notice issued by the head GB and GBs dated 1/10/2024. Directing the petitioner to appear along with the statements, along with the witnesses before the KEBA committee, before the KEBA on 03/10/2024 at 2 p.m. at Kebangon, Monigong, Monigong, on the ground that the petitioner, the Additional Deputy Commissioner has no authority to issue the impugned order as the jurisdiction of Additional Deputy Commissioner has been done away in view of the done away by the act of legislation, that is i.e. by enactment of Arunachal Pradesh Civil Code Act 2021. Issue notice returnable by 3 weeks. Mr. Wide Land Council for the United States Council entered appearance and accepted notice on behalf of the respondent number 1, 2, and 3. No formal notice to ensure. In this our exec office, Mr. The petitioners to take steps for service of notice upon respondent number 4, barrister pursuant within 2 days. Heard the prayer for entry. List of. The matter was allowed to be listed, allowed to be moved as unlisted motion today. And the same was taken up at 2:30 p.m. Whereas the KEBA was supposed to be conducted on 03/10/2024 at 12 p.m. list of. Well, this when the matter was when the matter is heard, it's already 3 p.m. Therefore, staying there, passing the interim order, therefore, it would be futile to pass an interim order at this point of time.
Cover proceeding has just started now.
List of. Once it is started, we cannot stop.
Impugn order may be state.
What impugn order?
13 September 24.
That has already gone. It is referred. The KEBA is conducting now.
What I am saying,
still subject to outcome, any decision.
Or maybe state.
No. It cannot be state now. On reference, whatever. After taking, I will accept that after taking cognizance, it was referred. KEBA has conducted. You didn't appear. Today they have fixed it. 11th hour. Had it been yesterday, we could.
Yesterday, there was a holiday, so why we could not file.
Day for yesterday.
May kindly stay the impugn order.
Cannot be. It's of no use.
Or the proceeding of the this KEBA
will stay subject to outcome of this petition. Considering the above, the proceedings of the KEBA that may have the considering the above in the interim, it is provided that the decision of the KEBA shall be subject to outcome of this.
Otherwise, status quo. Status quo.
What is status quo? We don't know what is.
Because this KEBA are mechanically.
Yes, subject to outcome.
Yes, ma'am.
It's this much protection we can grant.
They may say, they may force me to appear.
I have recorded the time and passed the order. It will help you. Because ultimately decision would be whether the DC has ADC has the authority or not.
Yes, ma'am.
Once it is, it should be nullity. That's why I said subject to outcome. More than this, we cannot. Yes. This is what? Yes.
I think 21.
Unlisted.
No, Lordship.
What is this? Is listed for what? Yes, yes, all item. Why this has been mentioned?
Item number 36.
36 unlisted.
Your Lordship, it's mentioned for withdrawal, yes. Your Lordship.
MS
Sonam Somu.
Sonam Somu.
Yes, Your Lordship.
Sonam T.
Yes.
Or Sonam T. Somu, learned concept of the petitioner, says that she has an instruction to withdraw the present writ petition.
Liberty may be granted.
Please stop. Therefore, she prays that matter may be, the writ petition may be allowed to be withdrawn with a liberty to file afresh. Please stop. The prayer for withdrawal is accepted. Please stop. Accordingly, the writ petition distance goes on withdrawal with liberty as prayed for.
Much of
Item number 22 and 23.
After Puja vacation,
Madam.
where are you? Have you not been posted anywhere?
Yes, my lord, I have now been.
Are you hanging?
Yes, I have been released now since there is a stay order
You have been released from where?
from Pasigat
To where?
to
Will provide in the in view of the order passed in view of the stay order, he should be allowed to stay at Pasigat.
My lord.
Till the return till the disposal of the writ petition.
My lord.
Reason is very simple. We'll allow the writ petition.
No, my lord, this writ petition cannot be allowed, my lord.
Why?
Because, my lord, there is a transparent posting policy, my lord. To have seen, my lord, is.
Why not the division bench judgment where this code was one of.
Now, my lord, this is there is a.
That's what I'm saying. I'm indicating you. 2 months back, I think, have you gone through that? On the same issue. We have interpreted, I don't know if it is not taken to Supreme Court, I don't know. You are saying that if he is posted in the headquarters.
Yes, madam.
It is the preparation paper book, I mean the paper, pencil paper.
Yes, ma'am.
It will be more convenient for them to have prepare the pencil paper in the headquarters.
Yes,
that interpretation this court has given.
And not only that, my lord, maybe that, my lord, while framing this, issuing this guideline, the government might have in their mind that, my lord, the officer who are posted in the division, my lord, they should be transferred out to headquarters. That is the reason for this framing this policy might not only confine to, my lord, for the convenience.
You may be correct. Another problem is unless we get that order, and if it is not distinguished, you have not come across that judgment.
My lord,
same issue.
My lord, I'm
1 year before the completion.
Yes, my lord.
1 year.
Because, my lord,
the retirement.
while this framing this policy, my lord, the intention of the government, my lord, can be twofold, my lord. Firstly, to
that's what I'm saying. That has been interpreted by this court,
my lord,
the division bench of this court.
Even there's no ambiguity, even the guideline itself.
Authored by this court while sitting in the division bench.
And my lord, one account, how the earlier transfer order that's written has been modified. That's at request of the.
I would like to hear both of you placing the judgment also.
My lord.
Whether this is distinguishable or not.
My lord.
Otherwise, I'll hear you, I'll keep it, I'll have to do my homework again. And that will be behind your back. If this court held that it has been settled by the division bench so and so, you'll not be given an opportunity. It may be distinguishable, I'm not sure. But on the same issue, you find out, try to find out.
Yes.
Next date. Don't take it as an excuse. There's no problem.
My lord.
Hearing you and decide the matter.
My lord.
But in view of that interpretation, the petition will be allowed.
My lord, only the urgency in the matter is that, my lord.
It's matter
of 3 months, my lord.
Private respondent, my lord. He's hanging now, my lord. And my lord, of course, I am hoping I'll be relying on this transparent posting policy. My lord, I'm very sorry to say that I have not come across the judgment. What have this honorable court has observed in that very case, my lord. Okay, my lord, I'll try to find.
You find out.
Out the judgment.
Maybe you may have a different. I'm not sure.
My lord.
But I vaguely remember that this issue transfer 1 year before the that thing, that provision in the guideline
Yeah, my lord.
has been interpreted.
Even a coordinate bench, Tripura, my lord, they're also the same issue.
From
Yes.
this from the state only. I think PWD same.
My lord, the petitioner, my lord, his contention, one of his contention in this writ petition is that, my lord, since he has not been transferred out before 1 year, 1 year before his superannuation.
We have
Now, the problem why he was not transferred out, my lord, because my lord is very much aware of the fact that that very point of time MCC was in the force.
Petitioner has
Model
already
code of
initiated the paper, pension paper, and everything's on.
I don't know unless you brought on record whether there was a MCC or not.
Yeah, I brought it in.
Unless it is brought on record.
The matter is fixed on 23rd. We
Yes.
go to that.
Yeah, you find it out.
Yes,
maybe it may not be relevant also.
23rd.
I just
23rd
vaguely
is not
remember.
possible.
22nd.
No, let it be 24, madam.
24.
No issue.
No issue.
On on the consent of the learned counsel for the parties, let this matter be listed for admission hearing
Yes, madam.
on 24
Madam.
10/2024.
Yes, obliged, madam.
Mhm.
24, 25.
Yes, what is this?
Your lordship, this matter pertains to the cancellation of the transfer order, your lordship.
Cancellation of transfer.
Of the transfer order. That transfer order actually, it was
What is
issued.
IA for?
IA was, your lordship, when the matter came up for motion, no order as to the interim prayer was made, your lordship. When the matter first came up for motion, your lordship,
Yes.
then with regard to interim prayer, there was no any order, your lordship. So thereafter that IA for the consideration of interim prayer was made, your lordship.
Yes.
And today was fixed for a hearing on that prayer, your lordship.
Why you have not made a prayer?
It was made, my lord, it was not accepted by the court. That was the case. Although it's not reflected, but it was truly heard and said that it's not, since it is the same place of posting, same station, there's no station transfer. That was the concern.
There was no any express order, your lordship.
Where
It was at the page 20 of the writ petition, your lordship. This was my prayer, your lordship.
Tell us what is the fact?
Your lordship, actually, your lordship, may I bring to you at page 25, your lordship,
Of what?
of the writ petition. your
Writ
lordship.
petition.
Yes, your lordship.
Yes.
This is my representation, your lordship, where I requested for my transfer, your lordship. Though at the same place, I was working at DC office Changlang. I prayed for my transfer to DMO office Changlang on the ground that
Within the same building.
no, not within the same building, your lordship. But department are different, but at the same place, because my ground was that I was suffering from pulmonary tuberculosis.
It's okay.
So
You
lighter
have
work is,
requested for transfer from judicial branch to the DC office to DMO's office.
DMO.
Then
I enclose my 26, 27 is medical report, then
forget
28
it,
is the
forget
order.
it. Then
28 is the order. It was granted, your lordship.
you are Wangdam Jamoy.
Wangdam Jamoy, your lordship.
DC office there.
Then your lordship, I was released also
By DC.
by the DC.
Yes, then
Then when I
You have
went to
joined-
DMO office with joining report, the DMO office did not accept my joining report and no, your lordship, reason
this
has
has been cancelled.
and no reason has been assigned, and pursuant to this, your lordship, I made the representation that my joining report has not been accepted to the DC, but later on I came to know that it was already cancelled on the very next day of the issuance of my transfer order. That is at impugned order is at page 35.
Joining back to, this is page 36.
Page 35, your lordship. The impugned order is, this is the cancellation order.
23rd July.
Yes, your lordship.
What?
And
This is your representation is
my representation was 24th, your lordship. It was on 24th, but your lordship, if your lordship may see at page bottom side of the page 35, I received this on 37 itself, your lord. After I gave that representation, thereafter I received that.
nothing,
Your lordship.
nothing.
Your
What
lord,
is your right?
no, your lordship, I understand. I
Then-
do not have right, and I completely understand that because transfer is the prerogative of the employer. But your lordship, the law has been settled by this honorable court also.
Saying
That
what?
with regard to the cancellation or modification of the transfer order has to be backed with sufficient reason, your lordship.
What sufficient reason?
Your lordship, and last year also division bench of this honorable court has also passed the judgment in that effect, your lordship.
Your initial order was passed wrongly. It has been correctly cancelled. You are UDC of the Deputy Commissioner's office.
Yes, your lordship.
It is interchangeable.
Yes, your lordship. Because ministerial cadre,
As you will require, but it's the DMO office, we are not required of his service now. Only a requisition only.
Only requisition.
Yes, yes. He's the staff of the Deputy Commissioner. This is cadre. District cadre. This is not a transfer basically. This is an internal arrangement only.
but my transfer was done with a proper transfer order, your lordship. My transfer was effected with a proper transfer order, your lordship. Although it has been
Same premises only, lordship. DC office, DMO office also is there, lordship.
No, the departments are different, premises
How
are also
far it
different.
is?
Your lordship, it's around 1.5 kilometer away.
Very,
But the
very long distance.
No, not a long distance. Distance is not the problem. The work, the nature of work is there, your lordship. It's
Then-
because that was a lighter work, and due to my health issue, your lordship, I wanted to
leave your job, take a voluntary retirement. We will direct them to give you a forced retirement.
So, your lordship, the in transfer matter, the only thing which I can do is to give a representation, and that was accepted. But cancellation, whatever the learned brother is
What is
saying,
right that you should be transferred at in the DMO's office?
I don't
What
have,
is
I
right?
don't have right.
If
I
you
agree
don't
with
have
that.
right, nothing.
I don't have that right. I can request only. I can ask for transfer on request only, your lordship.
So your request has been accepted.
It has been accepted, but
And
why
now-
it has been
Now
rejected?
that has been cancelled. Better ends there.
That to your lordship on the recommendation of the DMO, your
Yeah.
lordship.
The
But
DMO
here the
doesn't-
DC is the appointing
DMO
authority.
doesn't want you. Why you want to be there?
So why I'm not wanted
You
by
want you don't want to work. You want less work.
I just wanted lighter duty, your lordship. That was the only reason
No,
for
that is
which
a good ground. I will recommend, I will direct them to consider you to release you from the service. If you cannot perform, take rest of your life. Forget about duty. Should we direct them to consider releasing you from the service
no, your lordship. That
on medical
that is,
ground?
that is not.
Then, if you want to be in the service, you will have to work.
Yes, your lordship. But
I understand your lordship, but
If you understand, finish. Dismissed. Read petition.
your lordship, my stand was only that, your lordship, when why my transfer order has been cancelled, and it has been cancelled on completely extraneous consideration, your lordship.
What
On the-
extraneous? What extraneous?
Because just subsequent to the non-acceptance, whether DMO has
It
the,
is extraneous. What do you mean by extraneous?
your lordship, when we go through page 31, your lordship, no reason has been accorded. Why my
Lordship,
First, you ask, you show us what is the right, what is your right to be posted at DMO's office?
Because originally I was, your lordship, originally I was appointed there in DMO office only. The thing is that, your lordship, in the ministerial cadre of different department of the government of Arunachal Pradesh, the appointment are being made by the DC. After the appointment, your lordship, the ministerial cadre are being delegated or deputed in different departments, your lordship. So I was though appointed by the DC, but I was
Mr.
N. Sharma, your lordship.
Answer learned counsel for the petition. And also heard Mr. T. Tapit, learned S. Tapit, learned senior government advocate.
120.
And for respondent number 120, and Mr. T. Tagum, learned counsel for the learned standing counsel for health department. Ah, respondent number 3. Yes, what is to be done? After 4 weeks, or I'll dictate the order.
Lordship, just one is motion. Here, Lordship, if Lordship see the Lordship read petition, Lordship.
Have you filed the affidavit?
Lordship, the ground is Lordship, no region has been assigned, Lordship. There's a judgment of this Honorable Court, Lordship. This is Ranjit Chandra Verma's case, Lordship. Where it says, Lordship, when there's no change of station, Lordship. The internal language, no region has to be assigned, Lordship.
Your lordship, I have to go through this because my judgment.
It's a long time back
how
to the
far
8th judgment.
It will be applicable in this case. I have to go through that also.
After arguing the matter at some length, Mr. N. Sharma.
Yes, your lordship.
Learned counsel has prayed for adjournment of the matter on the ground that he would like to go through the judgment and order rendered in the case of.
This is 2008 2 GLT.
Name of the
party, this is party state of Assam versus Ranjit Chandra Verma.
State of Assam versus
Ranjit Chandra Verma and others.
Ranjit Chandra
Verma
and others reported in 2008
2 GLT.
Huh?
2008 2 GLT.
2008 2 GLT.
786.
Placed by the Lana Senior Government Advocate, Mr. Tita. List of.
And it has been reiterated in Dilip Kumar Sharma's case also in subsequent judgments.
All division bench.
All division bench.
Although, on hearing the parties, this court prima facie points no case to be interfered with, no grounds to be interfered with. The impugn order of transfer and posting and its cancellation, as the petitioner has failed to establish the right of the petitioner, his right to be posted or placed at the DMO's office. List of not place, comma. The Mr. N. Sharma,
yes,
is granted another opportunity.
Yes.
To argue the matter. List of accordingly. Prayer for adjournment is granted. List after 6 weeks. When? 4 weeks.
6 weeks will be, the matter will be infructuous.
4 weeks. 3
Your
weeks.
lordship, as short as possible.
2 weeks.
No issues.
These are unnecessary cases. You advise your client.
Deeply obliged.
26.
No
Yes,
affidavit.
Your Lordship. Here, Your Lordship, the respondent are yet to file their.
Who is the respondent?
Here, respondents are Information Commission.
Information Commission.
And State and Health Department.
And Mr. A. Bhattacharya, learned counsel for the petitioner. None appears for the petitioner. And appear for the respondent. Are you also,
Yes, I'm also, I'm for my respondent, my lord.
Mr. Targum appears for respondent number?
Respondent number, my lord, 3 and 4, my lord.
In that case, none appears for the respondent number 1 and 2. 1, 2 and
1, 2.
1, 2. Despite service of notice.
Yes.
Please do. Mr. Tagum, T. Tagum, standing counsel for Health Department. Appears for respondent 3 and 4. List the matter after 3 weeks.
Well,
in the meantime, parties may exchange the affidavit. And parties, the respondents may file their affidavit.
Deeply after.
27.
Yes, this is.
Lordship, here we have already filed affidavit, Lordship.
You have filed it.
Already filed, Lordship.
You have already filed?
Yes.
Who is for the petitioner? None appears for the petitioner on call. Interim order is there.
Yes, regarding the written examination also. On selection process is there also.
It is notified the impugn notification in the response shall proceed but the written examination still remains as until further which shall be subject to.
Maybe this is immediately after vacation on 23rd.
Let's see. None appears for the petitioner on call, huh? Mr. Next paragraph, Mr. S. and Council, Senior Government Advocate has submitted that. He has filed the affidavit on behalf of the state. State response. Listed matter up to Puja vacation.
My lord, extremely sorry to inform, my lord. At number 23, there's an interim order, my lord. That interim order may be allowed to continue.
Interim order earlier. Interim order first earlier shall continue.
23, yes. I'm deeply obliged.
Any surviving cause?
Yes, Lordship.
Why?
Lordship, here.
How?
Because of the interim order, Lordship. There is still the land.
Interim order is what?
Interim order in my favor, because the land which was allotted to me has been subsequently allotted to the BJP and the Karate Association.
Yeah. So there is an interim order against the allotment.
Yes.
Yes.
Here, Your Lordship, initially it was allotted to the Itanagar Club land measuring of 400 square kilometer, Your Lordship, square meter, Your Lordship. However, it was cancelled by the government and re-allotted to private respondent number 6 and 7. As on date, no cancellation order has been issued. Land allotted to private respondent number 6 and 7 due to sub judice of the matter before this honorable court, Your Lordship. And Your Lordship, this land come under
Forget about that. They are challenging the, not because of subsidies, they are challenging the allotment
Yes.
of to the BJP and the
And the Karate
Association. According to them, the land has already been allotted to
Yes.
the petitioner. 4,000 square meter.
4,000 square meters.
Out of the 200,
2,500
2,500 allotted to the
BJP and 600 square meter has been allotted to Karate Association.
Yes. Then in that case, 1,900 something.
Yes. More than
900 square meter is with you. Are you still occupying?
No.
Are you still occupying the land?
Is still no lordship. At present, the BJP just after getting allotment, they started construction. Some structure is there. But because of the interim order, now the land is the construction is also lying there.
You have to justify the allotment.
Yes.
Yes, Your. For that, lordship, on previous occasion, this honorable court has issued and directed to the direction to the government for clarification regarding the subsequent cancellation and the status of the land. But they have also filed their affidavit, but nowhere they stated any clarification regarding the exact status sought by this honorable court.
By which order?
By lordship, on 3-4 occasions, lordship, it was 29/5/2024. Council was directed to take instruction regarding cancellation of allotment orders in respect of 6 and 7. And then on 30/5/2024, again directed to take instruction regarding cancellation. And on 4/6,
cancellation means
cancellation
your allotment, cancellation of your allotment.
No, subsequent. Now on that day, the council was made a submission saying that
That allotment order
Yes,
issued to
6
the
and-
impure order has been cancelled.
yes, 6 and 7.
Here you also we
It
have
was verbal submission.
we have taken the instruction. Also, we have received the instruction from the
What
department.
is the
Your
instruction?
Lordship. And Your Lordship, this honorable court was instructed to file additional affidavit. Your Lordship, we have filed already, Your Lordship.
But
Yeah.
it doesn't say anything.
Yes, Your Lordship.
nothing, Lordship.
They're same, Your Lordship.
Where it is?
Your Lordship may come to this one in our additional affidavit. Paragraph 4, Your Lordship.
Additional affidavit.
Yeah, when additional affidavit.
Page 17, paragraph 4 and 5, Your Lordship. Same, Your Lordship, like earlier we have filed in our this one, Your Lordship.
You are taking it to the different level now.
Yes, they are taking
It's a
some-
forest land.
Yes.
It has to be obtained.
Yes.
In our affidavit, Your Lordship, is written to
It's
forest
against you
land, Your
also
Lordship.
now.
Yes, now
The
it will put
committee
them in.
had-
committee
committee
that-
had- the committee
Durpang Reserve
appears to
Forest,
have
Your
gone against you. Durpang Reserve Forest.
Yes, Your
all this.
Lordship.
Yes, they are taking different ground. Then entire Itanagar, even the secretariat officer will also go, Lords.
So, in essence, it has not been cancelled.
Yes,
not been
It is
cancelled.
still standing.
yes.
Some other. On the joint prayer of London Council Public Parties, let's this matter answering puja vacation. Though it is of 2018.
Deeply obliged.
Bless you, Lordship.
मैं आपको नहीं चाहिए